You have not got the certified copy?
Yes, yes.
Then why are you taking leave?
Then my lord, I file and
Give the date in the presentation form. It will appear on that date.
এই তোমার বাড়িতে পুজো করছো? সমীরদা, তোমার বাড়ি পুজো, বাঁকুড়ার পুজো?
Your Lordship had directed May 20 Now your Lordship has seeking clarification from the pay to the Lordship. I have been,
You don't know the Union of India.
but I have inquired from them. They are also not unable to say.
কোন লোকটাকে
Right, file the application.
My lord, I am praying for leave to file a substitution without the certified copy.
Why? What is the urgency?
My lord, the order was passed on 4th of September. There was an order of status quo regarding certain properties, including bank accounts. Now, my lord, a purported application was filed by some persons without revealing their identity.
All right, leave granted. File. You have the server copy with the server. Yes, Mr. Chakravarti.
Lord, item 401 of your Lordship's list. Lord, this was fixed 4 p.m. today.
Yes.
But in the list, there is no marking.
401.
401, Lord, I have inquired from your Lordship's officer. It is marked 4 p.m. But
Who
in
is
the
appearing
list,
for the other
Mr.
side?
Devjit Mukherjee.
Inform him.
Lord, I will do that. But in all probability, they want to delay it. They will come and say 401. I have not brought the file. Lord, can you mark it tomorrow at 4
Mr.
p.m.?
Chakravarti, what can be done? Mistake, what can be done?
Lord, tomorrow marked in the list. Lord, I know what will happen even if I takes it over 4 p.m. I know what will happen.
কালকের দিনে করে দিন।
I know what will happen.
Inform the other
I
side.
will give a notice to them that my lord has kept it tomorrow. But may it be tomorrow at 3 p.m.
You said 4 p.m. Why 3 p.m.?
Tomorrow, Friday, my lord knows, my lord, there may be a resolution 3:30.
Maybe. If there is a resolution, it will not be taken up.
Very well.
This is an extreme urgent matter. My lord, I am the mortgage of property. My property has been sold under the
আমাকে বলে দে, আজকে আসতে হবে না?
People will not.
বসে পেরেছো নাকি? আবার
Here it is
বোঝা
order.
টাকা আলাদা করে।
My appeal has been dismissed. In the meantime, taking advantage of that order, they are changing the nature and character of the property.
Hand over the slip. Yes, call the
Lordship, may I probably issue section 24 for Lordship.
section 24, right? Predetermination. Why are you mentioning here?
But section hukum number 24 is not fitting. That's why
Has it been assigned to me? I do not know.
The filing, my lord, I'm sorry, my lord, my lord, the filing department will not, my lord, place the matter tomorrow, my lord, write down on my.
Put it day after tomorrow. What is it? One day, what will happen, Mr. Ganguly?
Lord, I had mentioned an urgent matter yesterday, my lord, for inclusion and for taking the matter up earlier with indicating the urgency in this matter, my lord. But the matter has not been.
It will be considered. Yes. Yes, call the list.
Item number 1.
Lord, yesterday my lord was here. This matter.
Party. Lordship had asked me to take instruction on Lordship. On Monday 15th, the child has his maths examination. The mother has sent the routine, the schedule of examination.
Monday.
On Monday.
Monday.
Mathematics examination on Monday. On 15th.
Which class?
Grade 2. Class 2.
Grade 2 means class 2.
Class 2.
Nothing will happen. I can reduce the time. Nothing will happen.
It's a major distraction for two students.
Instruction. Other than instruction.
It will be better.
Huh?
It will be better. He or she. He will perform better. I
Yes.
can assure you.
Then
If he meets with the father, he will perform better.
Lordship, one more
Mr.
submission.
Chakravarti, then the time is to be reduced. After all, you are the father. You have also to consider.
Just let me indicate one more thing, Lordship. When I am instructed that when the father met physically in the lawyer's chamber in Barashat, instead of spending time with the child, he spent more time in misbehaving with my client.
He will later not come.
He
That wouldn't have come.
Mr. Chakravarti, don't enter into this. The child has to be accompanied by the mother.
The mother would
let the mother be
Ask
there.
your client not to misbehave with
not
you.
only
Not to misbehave with the mother.
I will ensure that.
Same Lordship, for whatever period of
is-
time the child is spending.
If that is anything is done, I will take so.
Definitely.
I'm keeping it on in the next week. What time will be convenient?
কি চাইছো?
মা থাকবে সাথে।
No, if the
mother
mother
has to be there
stays
with
with the child, then how will be the visitation?
The mother has to
Uh,
be there with the child.
That
Your
is
Lordship.
purpose.
No, Mr. Chakraborty, mother has to be there. I will
Hey,
check that.
8-year-old child.
What would be the ideal time for that? Because since the exam is there, what would be the ideal time?
Ideal time, Lordship, my instructions was that they cannot come on this Saturday and
That cannot happen.
20th, Lordship, is the scheduled date for meeting the child in the lawyer's chamber.
No. It will happen after prior to that. So, what time will be convenient? That is why I'm asking you. Please tell the convenient time. Because since the exam is there, class 2 maths exam,
আচ্ছা, ওটা থামো না।
nothing will happen.
তুমি কেন জজ বিচার করবে হয়েছে
But
কি?
3 months exam
তুমি করবে না, এটাই ঠিক কথা। তারপর কি হবে?
Yes. What will be the convenient time?
as low as
12 to 2.
12 to 2
Mr. Chakraborty, 12 to 2 because
in
since
presence of the mother.
Only one request to your lordship, only one prayer. Let the mother bring the child, sit in the food court, hand over the child to the father. After 2 hours, we will return the child.
No,
in the same place, the mother has to be there.
The mother, if
But-
the mother sits in the same table, how will the
What is
visit
the-
take place?
You said in the playing zone.
Yes.
So playing zone, mother will stay there, but will not. I will protect that.
the child has to be there within the side of
But
the
I really wonder only one thing. I really wonder only about one thing. Lord, he is my son. I become not a danger for a son. What kind of submissions have been made?
I'm appearing, I'm
This
submitting on
application
instruction,
under-
Your Lordship.
This application under
They brought in a lot of new facts that have not been pleaded anywhere else. Lordship, may kindly,
I have not gone into any of the facts, only produced the son.
Lordship, may kindly just allow me to give a reply or
By 19th, let him give. By
Affidavit in
19th, let him
opposition.
give. By 19th,
That's
my lord,
whatever
kindly,
you want.
my lord, kindly record that by 19th, he will give the report.
Lordship, may kindly record it.
Let him give.
To which application? This
Demolition
application.
Let him give.
A lot of new facts have been brought in. In none of the trial courts, such
18.
facts have been pleaded.
By 18th, let him file.
Chakraborty, you have brought in new facts in the civil division application.
Let him file.
So why? Why are you introducing
That's
this
new evidence,
system?
Your Lordship.
Why have you introduced new facts in the civil division application?
Let him deal with it. That's what I'm saying. Lord, let him deal with
So
it.
why? Why are you introducing this system? That is why I am asking you.
I have to take the responsibility now, Lord. It was not done by us initially. So, Lord, with that as well, let him deal with that.
The learned advocate appealing for the দিয়েছেন তো একটা কাগজে। Yes, yes, yes. Have you shared it with him also? You have checked up.
Citizen got to food court at 12.
Right, number 2, my lord, I am appealing for the petitioner. Oh, what? Is it
My lord, in this matter, my lord,
I need to call on no one side. Yes, my lord, I am appealing
That
for-
occupation charges.
No, my lord, undertaking handed over to on the last occasion, my lord,
As well as the amount to be paid.
amount paid,
Amount paid.
receipt, my lord, on yesterday we have transferred. Now, my lord, only one thing,
Have you seen the
Well,
undertaking?
my lord, only one thing I will
Undertaking is not-
indicate,
my lord,
I will indicate. My lord, firstly, my lord, the undertaking filed before my lord.
intentionally it is done, my lord.
আমি বলছি the undertaking filed before this court kindly returns to the takes this undertaking.
Whether
There is a
it is-
mistake, typographical.
Well, let it be there, my lord. Both may be there.
No,
Both
because-
may be there.
Both-
My lord, it will future.
No, no,
report,
no,
my
no,
lord.
no.
Yes, no.
তোমাকে যেটা দিয়েছি সেটাই রেখেছি।
No, no, what happened? What is the mistake?
Yes, my lord, I have prepared 2 undertakings. There are one undertaking pursuant to my lord's order which is recorded. But in that undertaking, I have prayed, my lord, I will vacate by February as recorded by my lord. But I stated that 15 days time to remove the articles because it's a hardware shop. My lord, if my lord doesn't allow, my lord says, my lord, on
Vacate means you have to remove, that's the order.
very well,
Vacate, that is why I have said, I think
That copy I
vacate
am not
has
producing.
possession.
very well.
So not removal of
My
articles
lord,
and others.
I am, that's why I'm saying, my lord, that's why, for that reason, if my lord,
Which paragraph in the earlier affidavit, please?
no, my lord, kindly takes this one,
My lord, paragraph 4.
No, no, because the
subparagraph
wrong
1.
affidavits.
which my lord is looking into. That is, my lord, on April.
Show me the paragraph.
ওই আগের affidavit টা-
Paragraph 4, subparagraph A.
না, না, আগেরটা দেখছি।
আগেরটা আমি বলছি। আমি
On or before 15th of April 2020.
That is wrong. That is, my lord, mistakenly typed. My lord, correct one is handed over to him. That is by 15th of
And the
March.
other things, there is that
There is no
difficulty.
No difficulty.
in March.
No, no, no. Mr. Chakraborty, except paragraph A, there is no difficulty.
Difficulty, no, that he has paid by cash. Those
Right.
who are-
So now let me, so this is the new.
This is the,
that has not been
না
served.
না এটাই তুমি যেটা বলছো 15th of March. ওইটাই please.
Direction was 15th of March.
End of February, my lord, I have stated 15 days for removing the articles.
No, no, no.
If my lord doesn't want, but I will not.
Mr. Chakraborty, Mr. Chatterjee, this is not the affidavit in.
No, then my lord, I said, my lord, my client is here, he's present in court, I have called him. My lord, I shall also.
File an affidavit.
Yes, yes.
Please file an
My client
affidavit.
is
Please
here.
affirm an affidavit in course of.
In course of the, because same thing only that date will change.
I'm only,
না না
that 115, please do that.
Yes,
By
yes.
115.
With the copy to me.
Yes, yes,
Please
yes.
serve him a copy.
Only that date will
Don't file this. Back.
return that also, that's
No, no,
wrong.
that shall remain.
That is a wrong one. This is the correct one. Should be, I'm correcting this one.
I will record that. This is also wrong. This cannot be allowed. So I will record your submission. Please bring the correct copy.
Very well. এখানে খালি একটা
In that,
correct-
whatever corrections you want, please do
Yes,
that.
yes, খালি
Affirm
15
affidavit.
15 মাসটা
And yes, Mr. Chatterjee, please take it back. Please produce it at that point of time.
2 p.m. Miller.
Not 2 p.m. 1:15 I said.
Very well.
1:13.
Very well. Very well.
Yes, yes, call the next matter.
Number 3, my application.
My lord, we are challenging an order dismissing the application under section 5. The order has been passed by the municipal tribunal
Section 5.
of the Limitation Act,
Yes, by the building
by
tribunal.
the building tribunal.
Yes.
Now, my lordship may kindly take,
Mr. Mujumdar, section 5 application cannot be rejected.
he has rejected.
No, cannot be rejected. That will be your submission.
Yes, cannot be rejected in the facts and circumstance of the case. Because, my lord, what we did, first, my lord, an application was filed.
Rejected with cause.
Yes,
So your conduct is not good.
my lord, the conduct of the corporation is not good. But your lordship had the occasion to consider this, but
Yes.
this particular demolition matter in another case. But my lord, my submissions are now restricted to section 5 application. My lord, kindly take your lord, may I take your lordship to page 124 first, before I take your lordship to the order.
Mr. Mujumdar, you have to serve upon the other.
My lord, I have to serve, but my lord, today is the date fixed for demolition. My lord,
This is Kolkata Corporation.
yes, Kolkata.
Can you bring anyone, Mr. Ghosh or Mr. Debnath, anyone who appears?
I think Mr. K appear করছিল এটা
Last extensive year.
Who is
মানে kindly bear me for 5-10 minutes, my lord. If your lordship finds that no order can be passed in their absence, my lord, then obviously.
Mr. Mujumdar?
But there is no caveat. There is
That
no
will be
caveat.
better. That is why I'm saying I appreciate there is no caveat.
But my lord,
Because you
today,
are saying today is the date of demolition. That is why I'm asking you.
my lord, your lordship may direct whoever your lordship may find.
Anyone, Mr. Ghosh, Mr. Debnath, who usually appears for the corporation.
ঘোষকে দিয়ে দাও।
I think
Mr.
Mr. Ghosh,
অলোক ঘোষ।
yes, Mr. Ghosh, I think anywhere,
দেখো।
please ask any of your juniors and
Yes. 3 নম্বর কোডে পেয়ে যাবে, দেখো।
can in the meantime,
Yes,
place it.
yes, my lord. Kindly take, my lord, the order dated April 25.
Please inform Mr. Ghosh, ask him to come.
Yes, my lord, definitely.
Yes.
Kindly take, my lord, this is when the application was taken up for hearing. Today is
What was the period of delay?
my lord, that there cannot be any delay. Because, my lord, under the Corporation Act and the notifications of the circulars issued by the corporation, the mayor and, my lord, the municipal commissioner, any order of demolition would have to have the approval of the mayor in council. As per their circular. We took out an application under RTI.
Statute does not.
Statute does not say so, but when we took out an application under RTI Act in the month of April 2024, the RTI response was that the order is yet to be approved by the competent authority. And that is why the order was never communicated to us. Well, there was a writ petition which,
So according to you, order was not communicated to you.
order was never communicated to us as recorded by the Honorable Division Bench in another round of writ
The
petition.
order passed by the special officer building.
Order passed by the special officer building.
It requires approval.
Yes, my lord, that is their stay, that is their, my lord, view. But may I just take your lordship to some of the dates? What happened in this case? First, a writ petition was filed by some private party, alleging that, my lord, unauthorized construction.
Unauthorized construction.
Writ petition was disposed of by this honorable court. My lord, Justice Sinha was pleased to dispose of the
Consider the complaint and
to take steps. This order was carried to the Honorable Division Bench. When the matter was moved before the Honorable Division Bench, the Honorable Division Bench directed that inquired why the appeal has not been preferred before the building tribunal. We pointed out to the Honorable Division Bench that the certified copy of the order is not available with us. So we can't prefer appeal. But the Honorable Division Bench directed that you go and file and the certified copy will be handed over to you. Malad, we filed the appeal with the leave of the Honorable Division Bench before the Building Tribunal in the month of November. Malad, 11 November.
Order passed on, date of the order.
11 November 2024.
No, date of the order.
No, Malad, the date of the demolition order,
Yes.
2022.
Date of the demolition order 2022.
Which we were made known, we came to know about the order only when the writ petition was served upon us in 2024. So, Malad, what happened? We preferred appeal. Once we preferred appeal, Malad, I think Mr. Mukherjee is appearing.
Mr. Mukherjee, you are appearing.
I've been told your lordship has called me.
Yes, yes. You can appear in a Kolkata corporation matter.
Yes, yes.
Yes.
Then, my lord, what happened? When we preferred appeal before the building tribunal, even at that point of time, the certified copy was not made available to us. The certified copy of
One thing. Mr. Mukherjee, Mr. Mujumdar submits that today is the date of demolition. From 11:30 or so, I
Yes,
think,
my lord.
when it was mentioned.
where is the notice
So
of
can you
demolition
stay your hands? Because you have been served just now. So if you can instruct your officers to stay your hands, I can keep it tomorrow.
Yes,
In the
yes,
morning, you can also take
Yes, yes, yes,
instructions.
my lord, I can.
For that, you have to assure that no steps will be taken today. If that is so, the
But kindly pass it over for 5 minutes, 10 minutes, minute,
all right,
because my order was passed on 27th August. This order. Certificate copy obtained on 1st September.
Mr. Mukherjee, I will hear you. If you said yes, you are ready with this matter, then I can hear it. That is why, since you have been served just now, you may require some more instructions. You may require some more instructions. If you say you are ready, then I can hear it finally.
Notice finding building patient
My lord, we have, that has been affixed.
That is why I am giving you time. And if you say you are ready, I can take it up today.
7 September 2025 at 11 AM to 5 PM.
From 11 PM,
AM.
11 AM. Mr. Mukherjee, please do it.
Kindly pass it over for 10 minutes.
10 minutes, please see the watch.
My lord,
You are appearing.
Mr. Ghosh and I actually appear in this matter, but my lord, 1 day's accommodation may be given.
Yes, that can be given, but Mr. Mujumdar submits that today from 11 AM the demolition will start. So assure that nothing will happen. I will take it up tomorrow.
Today nothing will be happen. I will for today only.
For today, I will give, not for today. Please wait, because tomorrow we will take it up for 2 days.
2 days and 2 days.
Tomorrow, so the same thing might
I
happen.
will inform the
So please stay your hands for this week. I'm keeping it
Well, I
at the
will
same
not-
position tomorrow.
1 minute for digression. My lord, your lordship may remember our batchmate, Devashish Mitro, Papi.
Yes, yes.
One matter was going on before my lord, Mr. Justice Girish Chandra Gupta, as his lordship then was. So that was a civil matter. So some demolition work started. And his lordship directed that status quo be passed. Status quo be made as regard the property. Bapi instructed, my friend instructed, status quo means that whatever you're doing, you continue to do that. When the demolition was complete, next day when the matter appeared before his lordship, what happened? Well, everything demolished. Well, we understood the status quo that we have to continue with the work.
Yes,
I-
so can you stay your hands for this? Then I'm keeping it tomorrow, but please stay your hands.
My lord, my lord, may I pray for this actually for 20 or 30 minutes, because one matter is going on.
20 or 30 minutes.
Because when I am
11 AM it
actually
will
the
start.
officer, he will ask my authority, because I am not.
Please do it fast, because 11 the demolition will start. That is why.
I will.
Tomorrow we will come, my lord. Tomorrow we will.
Tomorrow I will. Actually.
Today nothing will happen, Mr.
I hope,
Mojumdar.
my lord, we will, what we have done in the meantime, my lord, as an officer of the court, we wrote a letter to KMC as well as the officer in charge of the local police station, requesting them to wait for the outcome of the matter, only requesting them.
Yes, that is why. Mr. Das, please,
What we have done.
can you come at 12? Mr. Das, Mr. Mojumdar, can both of you come at 12? Only to take this instruction, whether he can, has given it.
I can stop, but that
You can stop,
some
my lord.
authority.
You can stop now, so I can record your submission. All right. Then I'm keeping it
Yes,
tomorrow. I'm recording your submission.
Only for the day, only for the, only for the
Only
day,
for the day.
only for the day.
Only for,
We will come tomorrow. Or my lord, Monday, whichever day.
no, I can keep it tomorrow. So, please stay your hands for today and tomorrow, because I do not know tomorrow at what time it will be taken up.
Yes, ma'am.
That is why. If you say tomorrow also from 11,
No, no,
that is the difficulty. That is why
I will inform the
Uh,
authorities and all, and then
this matter, Ashun, this matter was mentioned, now your junior has come, Mr. Mojumdar.
now my junior is arrived. Waiting for the matter to conclude, and now we are. Thank you.
Yes,
For the petitioner.
you have seen.
Yes, my lord, I have seen the lordship. My lord, actually, there was no order date of 24th of June 2024 in the order sheets, my lord.
Yes, so now the records have come, so I'm directing the learned trial judge to dispose of the. But you have seen the note. One thing is there is a resolution taken by the advocates not to appear before that court.
Yes, Lordship. Yes, Lordship, I have seen Lordship.
Then have you taken instructions with regard to that? If your counterpart does not appear, what will be done? Then it will proceed. Your prayer will not be accepted then. You face that risk. All right, Ashun. This application under Article 2.
This is my custody. My lord, visitation rights in the courts.
He is appearing for the opposite party, Mr. Light.
Twice in two addresses. Both has returned with the endorsement. I'll bring this on record, my lord. Yesterday it has returned. Both have returned with the endorsement insufficient address, my lord. Kindly compare the address. I'll bring it this.
Mr. Lahiri, if it has returned with the remark himself, that's not a good service.
But the we have sent in the in the address which is given in the application.
You have filed the application. You have filed. Then no, that address might not.
Memorandum of understanding is there. Her application is there. Kindly cease.
But Mr. Zahiri's service is not complete. So do one thing. You please serve upon the learned advocate representing her.
Then kindly keeps it day after tomorrow or in Monday.
Which court?
Well, this is my lord Barasha.
Please serve upon the.
Because my lord, what is the urgency, my lord? Why I'm saying in the last
I
occasion,
appreciate that. First of all, this is a custody matter.
yes.
So and the service is not complete.
kindly keep sleeping next Tuesday, my lord. I'll be praying for
Not satisfactory, if I can put it in that
yes,
way. Not complete.
satisfactory. I'll be
Not-
praying for my lord temporary custody in Durga Puja, Kali Puja, and her birthday. Well, it was orders have been passed on previous occasions.
No, but in this case, it has been rejected.
In this case, at my instance, the special officer was appointed.
No, this has been rejected. Prayer has been rejected.
No. First occasion, it was granted in 2023. She didn't comply.
No, what happened in this time?
In this case, my lord, the special officer has the order has been order has been, my lord, passed to meet the, my lord, child in the court premises in presence of the special officer. Special officer appointed at my instance. Since there was an order to
No, that is regular visitation.
regular visitation.
That is with regard to the regular visitation.
Yes.
Now you are saying that
Durga Puja order was also there in 2024. She didn't comply.
all right. So for this year, have you made an application for the Durga Puja?
But
Before
this
the last-
year I've made an application for regular visitations in the presence of the special officer.
Regular visitation is okay. Have you filed any application for during the Puja vacation?
During
Or any
Puja vacation, my lord,
for this year?
this particular year, my lord, there might not be, but my lord,
So,
the
Mr.
previous
Laidi, I am also giving you liberty to file an application with regard to that before the learned trial judge.
it was done. Previous year it was there. Order is there, not challenged. In the first
That is for
amendment,
that, Mr. Lahiri, that is for that period only. That is for that year only.
it was not complied with. Well, it is, I'll show consistently.
Not complied with.
No, not complied with. Consistently. That is why I had sought for modification. That please modify the order. Please appoint someone from the court so that she brings. Because when I go and say repeatedly, first order passed that she should bring the
You are
child.
willing to pay the cost. of
Yes,
the
yes,
special
yes, yes.
officer.
I have said so.
Which place?
My lord,
Where is the mother's place?
mother's my first order was in Axis Mall. Now, my lord,
Axis Mall of where?
of Rajarhat.
Rajarhat.
Not
Mother stays near.
my lord, Dokindari, I think. Dokindari. Lake Town.
So anyone, any advocate who resides near to that place.
I'll take
Because-
instruction. I'll take
Please,
instruction.
please see whether any
Already a special officer is there, and I will take instruction from
special officer is there.
Yes, the special officer was appointed. Kindly see.
So that was in the court premises.
Yes,
So he or
shop day during his visit to Sajata.
he or she may not be
Available to that. Yes.
for that. So any
Is anyone? Roshi may appoint
who stays
of
near
that
that,
locality.
otherwise
So that she or he can give the it may be convenient for them. I'll
yes,
come up
because
with
the
it.
convenience and the conveyance charge, we decide someone in Beala from
Dokindari-
Beala to go there.
Domdam Dokindari, Mr. Suwande is there.
Please see, because they have.
Oh, Lake Town, someone is there. We will find someone. New
Okay,
Town,
please,
Lake Town, during the pujas.
Please ascertain that. Ashun, Mr. Lai.
Order হবে আজকে? If the order is there, it will be easier. If the order
Please serve, otherwise because
My lord, is served, your lordship.
The sixth, I have been instructed to appear on behalf of the opposite party plaintiff. But Lordship, yesterday in the evening, my client has received his copy. He has said,
extension of time to deposit the cost.
Lordship, only the readings that I have been able to collect through WhatsApp. So Lordship, annexure and order till date I am Lordship about to receive from my client.
So you want a day's time?
Lordship, this is Rampura, Lordship, the 1 week time.
1 week.
You kindly see the track report. Lordship, I have been instructed.
All right,
Yesterday
so-
night,
The learned advocate appearing for the opposite party.
Petitioner, my lord.
Yes.
Suitable declaration of permanent injunction, my lord.
What is the,
Input
why it
the-
is appearing under the heading for orders?
My lord, yesterday, he paid for time and you should directed him to submit whether any applications are filed.
Kali Puja.
Yes, my lord, for Kali Puja or not. Nothing has, written application,
Yes.
no power
So
submission.
did you file any application? His submission was that,
application,
you have not filed any application and permission was granted.
interlocutory application was filed. On the
Show me
basis
the
of
copy
that,
of the
my lord, it
application.
has been annexed.
No,
That
it
is,
is
my lord, page 54. In the last year, based on,
This year, have you filed any application paying for permission?
no, this year, no separate application has been filed.
Then how
In
could
the
the
appeal,
permission, how could the permission be granted if you have not filed any
I tell you,
application?
I may tell you, lordship. What happened, my lord, the appeal was fixed for hearing.
Yes.
Well, if your lordship sees the order sheets, my lord, the appeal was fixed for hearing and it was heard in part. Thereafter, my lord, the business of the court did not permit to conclude the hearing and it was fixed on November after vacation. At that point of time, my lord, my lord, it was
On the
submitted.
basis of oral submission.
It was submitted on the earlier occasion. In that event, my lord, if your lord, my lord, the last occasion also, in the last year also, my lord, this similar order was passed on the exactly same order was passed. So, my lord, this year,
Last year also no application was filed.
yes, that application, on the basis of that application on interlocutory.
Last year, on the basis of an application, order was passed. And this year you have not filed any application and an order has been passed.
There was no scope for, my lord, kindly seize the order.
Ashun,
My lord, the liberty will be granted because, my lord,
liberty will be having.
my lord, take up the matter, my lord, before vacation because, my lord,
Mr. Das,
26th, my lord.
how many years you are performing puja there?
More than 50 years.
No, my lord,
We have a
nothing.
counter claim.
Last year they have performed.
Only last year. Only last year.
No, in that event, my lord,
Only
kindly
last
the
year.
records. 50 years, my lord, all the records are there. Counter claim is there. We have a counter claim.
The
My lord,
suit was filed, suit was filed when?
suit was filed in 2021,
I have purchased the property 2020.
2020. And my
At
lord,
2020, filed a suit. My
he is a
lord.
subsequent purchaser. My lord, the Kali Puja was held, my lord, for the last 50 years. My lord, we have an application under Order 1, Rule 8 also. Now, my lord, all these things are there. Counter claim is there. And my lord,
Mr. Das, only one.
my lord, the advocate
If
commission,
the earlier year the permission was granted.
lordship.
Only one
You
year.
have not, yes, maybe only 1 year.
Yes.
Last year it was granted, you have not challenged.
Yes, it was challenged, and
Challenge.
my lord, it was not interfered
Challenge.
by this honorable court.
Challenged by the Supreme Court, Honorable High Court, my lord.
Then it was challenged but not interfered with.
No, that is, Malik, can you see the order 65?
Yes, can
Why not interfere? Can you see, page 65? Why not
Page?
interfere? 65. 65. 65, page, paragraph 4, my lord. The order impugned dated 7/10/2024 did not be interfered with at this stage while hearing application sitting in vacation. That is only the observation, my lord. Not interfered into the merit of the case, merit of the application.
There are two ways. One thing is that your appeal may be then delayed, or I can permit them for this year only without creating any equity,
Yes.
and the appeal
No,
to be disposed
no,
of.
my lord, kindly, direct dispose of the appeal before this vacation. Before Puja vacation, dispose of the kindly item,
Dispose of the
appeal. Miss
appeal.
Already pardoned, my lord.
Appeal has been fixed. Appeal will not be cannot be preponed. The
lord,
date of hearing of the appeal cannot be preponed.
Only one submission, my lord. I have got an order of injunction from the learned court. If
All
it is allowed,
That
we
was
can-
modified. That was
Appeal, the
modified.
date of hearing of the appeal cannot be preponed.
That was
Date
modified.
of hearing of the appeal cannot be preponed. I can set aside that order, giving them liberty to file an application.
Yes.
You will file an objection.
Yes,
That
yes,
that application will be hard.
Yes.
But my
I have
lord,
no
before
objection.
vacation, my lord, my lord, the court is going to close, my lord, on 26th.
This
The
application
civil court.
to have filed an application, Mr. Rai.
Please, my lord, kindly appreciate, my lord, our conduct, my lord, in that
This
event.
application under
Please,
Article
this is the order sheet.
all right. This application under Article 227 of the Constitution of
I beg to the petitioner, my lord. Though matter has been appeared under the extension intending order, very short matter can be disposed of. My lord,
All matters are short matters.
my lord, probate matters, probate application was converted into a letter to administration.
This, after hearing the learned advocates for
My lord,
the disposed of, you're disposed of.
my lord, I'm taking only 1 minute's time. Later administration, there is a date of mentioning of the wrong date, that the wrong mention of the date of the execution of the will. It will be 15 to the 1993.
Correction,
Yes,
amendment rejected.
yes.
So goes
But
back.
it can't be. I will say words. It can't be because not the in the application date of will is different. Lord, your lordship kindly see the consequence. There may be another will. They have not disclosed anything in the application.
No, Mr. Ghosh, this probate application has been filed with along with the will. They have produced the will.
Yes.
What is the date of the will which has been filed along with the application?
Date of the will is separate.
Yes.
But-
So only they will correct
But Lord, your lordship kindly see.
the date of the will, that will only. Mr.
Lord,
Ghosh,
it can be presumed that another will was there because Lord, the original applicant, the executrix, she has in the evidence said that it is will dated as mentioned in the plaint.
no, Mr. Ghosh.
Now it is an
Yes, I
matter of
appreciate.
administration.
I appreciate a particular will of date X
Yes.
was filed along with the application for probate. In the probate application, it has been said that the date of the will is Y. So that's the dispute. So according to you, if Y is corrected to be X,
Yes.
then according to you, there may be another will of date Y.
Yes.
So now he is amending this. So it is not his case that there are, if it is it your case that there are two wills?
Lord, your lordship, I have no kindly see from it will
I am
appear.
asking you, is it your case that there are two wills
Lord,
of
it-
different dates?
Lord, it may be presumed that there was another will. Lord, they have not explained. They are in the application for amendment. They have not disclosed that there is no other will that dated such and such. Otherwise, can't be.
So that I
You
think,
kindly see their
in the application, probate application that has been said,
Lord, wait
where is
application.
that?
No. Now kindly see.
Where is the probate application?
Ballot annexure A, first document ballot.
Page.
Page, there is a pagination ballot, the first amended plaint. Last will and
Amended
testament.
plaint,
Last will and
not the amended plaint, original plaint. Where is the will? Where is the
last date and testament dated 1st February 1994.
where have you stated? Which paragraph?
Paragraph 1.
Yes, paragraph 1, 27th of July 1994.
Yes.
Now, where is the copy of the will which you have?
I have annexed it.
Where is that? You have annexed it here.
Yes.
Lord, last annexure, your lordship.
Last annexure.
Date of execution 15 June 1993. It will be 15 June 1993 instead of 1st February 1994.
No, this is 25th of July 1994.
Yes, Lord. Lord, mistake, maybe year, maybe month,
No.
maybe a date.
15th June,
Entire thing cannot be a
15
mistake.
June 1993.
1993.
Yes.
Now, where is your written statement, Mr. Ghosh?
Lord, this statement we have denied. Your lordship kindly see
So you have denied, what have you denied?
that there is no such will.
So according to you, there is no existence of any will.
And now, Lord, we have said that you are will and if anything is
No,
done,
that is with regard to the merits. That
Lord,
is
yes. And Lord, kindly see the date of death. That is in 1994. There may be a last will of 94.
No,
It is
Mr.
90
Ghosh,
will.
Mr. Ghosh, in the amendment application,
Yes.
you have said that this is wrongly mentioned as 1/2/1994, not that.
1 to 1994, it is wrong. 15 June 1993.
No, where 1/2/9, sorry,
Yes.
1/2/1994.
And the order impugned says so that correction instead of 1st February 1994 in place of 15 June 1993. We have produced it before the landed trial.
This will has been produced. as an
Produced and
exhibit.
not exhibit.
But Lord, kindly see this.
Yes,
His application kindly come to page. Not
25.
not paginated in my.
Annexure C, page 25. Mr. Ghosh, why have you not paginated the
Annexure
application?
D. Annexure D, Lord.
Annexure D.
Yes.
Annexure D is the will.
See written objection, Lord. Your lordship can, yes.
C
Is the
Yes, Lord,
application.
kindly see the application.
yes.
He should say that there is no such will of 94.
No, who said? You have, no,
He has not said anything. His simpliciter prayed for correction.
Yes.
Lord, you also is a suspicious circumstance because there may be
That is
at the time of drafting.
Mr. Ghosh, all points you will be entitled to take in the written statement, additional written statement.
Lord,
You take all those points.
Lord, he has been substituted as legatee and prayed for letter of administration. Or the original executrix, she has said it is will dated 1294.
Mr. Ghosh, I
In his
appreciate.
evidence, in her evidence.
Mr.
And now
Ghosh,
it is the argument stage.
only the date will be changed. Only the date will be changed.
In case of Lord other suit or other thing, I would not have said anything, Lord. But it is a case
I
of
will
will,
give you,
professional
Mr.
will.
Ghosh, I will give you right to file because you have to be given a right to file a written statement in this case. Additional written statement in this case. Amendment. You raise all points.
And Lord,
And
when Lord evidence is closed, argument on our part is
Mr.
closed.
Ghosh, apparently this is a typographical error.
Lord,
If you-
typographical error, not maybe year,
That has been
date,
stated paragraph.
or Lord month, but kindly say entire.
Mr. Ghosh,
Everything.
now are the days of those computer cut, copy, paste, everything same.
Lord, it can be done. I'm Lord, it is unless it was a case of probate, I would not have raised any objection.
I appreciate your anxiety. You raise all your points in the written
Should have
additional.
clarified it that there is no such will of 1294. In the application for amendment, he has not said kindly see simply said that is
Typographical
a
mistake.
mistake.
Typographical mistake inadvertence. The date of last.
What is the reasoning given by the learned trial judge?
That apart, Lord, why?
What is the reasoning assigned by the learned trial judge?
Delay, only delay. The reasoning is delay. After recording evidence as well as constitutional argument, it has
a huge delay. And after conclusion, Ashun.
5,000.
No. Don't bargain before Puja. Yes, next. There was a
Lordship, I am a bit.
Already
কোথায়?
allowed. Already allowed.
Can কিছু নেই আছে?
Already disposed of.
Extension of interim order till end of the September, Lordship. I
Lord,
also,
I am appearing for the opposite party, my lord.
uh,
I am appearing for the opposite party.
কোথায়? Oh, yes.
Virtually. Yes.
Yes, what is this matter?
probate proceeding, opposite party file an application for addition of
After hearing the learned advocates for the respective parties, the interim order is extended till the end of the month of February 2026 or until further orders, whichever is earlier. Yes. Next.
Gratefully, your lordship.
You are for the
Petitioner.
Yes.
The interim of
extension.
Yes, my lord. My lord,
Till which date the interim order was there?
my lord, till end of September 10th, 16th May 2025, last.
Till end of September.
Yes.
Have you served the copy of the
Yes,
civil
my
petition
lord, it's
application?
recorded in the last date order, 10th May 2025.
Have you filed an application for extension?
No, my lord, it's there, my lord, in the interim order.
But what is this can? That is what I am
My
asking.
lord, can is filed by the opposite
Oh,
party. for-
vacating. আচ্ছা করে দিন the learned advocate for অ্যাপ্লিকেশনটা ডিসপোজ অফ করবেন না ওটা কিন্তু yes Mr. Rai,
You have said, my lord, I learned that
you are appearing.
appearing on the response number 1 and 2. My lord, no
Yeah,
copy has been
So I have said, my lord. That is why.
Your copy, Mr. Rai.
He can say to take the copy.
After hearing the learned advocates for the respective parties, interim order
Yeah, 2012, my lord, little shorter date, my lord.
yes, next. Mr. Rai, did you file any application for extension?
No.
What is can 1 of 2025?
For extension, it is not required, my lord.
Is it for extension
Extension
of this extension?
of this.
Disposed of করে দেবেন তাহলে উপরে একটা লিখে দিন can 1 application for Mr. Rai, please serve him a copy of the extension application also. আরে কি
এই যে extension.
Extension ne ki korbe?
Just বলে
yes who is appearing?
I am for the opposite party number 1.
You are for the opposite party number 1. Who is there to propose? Oh, you are there.
I am appearing on the petition.
Yes. You have filed an application for extension.
No, application for, on the date of opposite party number 3, but petitioner not taking step before the trial court to substitution after lawsuit
So I could not follow.
date of the opposite party number 3, Gauri Shankar Jana. I filed
Date of the opposite party number 3,
Gauri Shankar Jana.
Gauri Shankar Jana. Who is he? This is a preemption proceeding.
He is the vendor.
He is the vendor.
Because no necessity for not proper party, so that but already in the original application you are implemented as a party, so that I filed this application to taking note of.
You are the preemptor.
No, I am the PMT.
You are the preemptee.
Yes.
No, my lord.
Yes.
He is a subsequent purchaser.
You are the subsequent
Yes.
purchaser from whom?
Yes, my lord. Preemptor is opposite party number 1 and PMT is opposite party number 2. He is the subsequent purchaser. Hello, kindly see page 2 of the cost title and application also annexed.
Oh yes. Preemptor is the opposite party number 1.
Yes.
Preemptee is the opposite party number 2. Who are you? Lordship, I am the Subal Chandra Jana, Lordship.
What is the order in tune? What are you challenging?
Yes, yes.
Order 8 Rule 6C, my lord.
Order 8, Rule 6C.
Yes, my lord.
Counter claim.
Counter claim.
What is the counter claim?
Title declaration.
Lordship,
Title declaration is on preemption application.
Lordship, fact of the case, Lordship, if Lordship permitted, Lordship, I place this case, Lordship, if any day, Lordship.
All right, so this is an application for substitution,
Lordship.
not for extension of interim order.
Interim or end of the September, Lordship.
This is an application for substitution upon the
Lordship, I am appealing to the petition.
আচ্ছা আরেকটা করে দিন ওই আগেরটাতে the learned advocate on record of the petition is directed to serve a copy of the civil division application upon the substituted heirs and file an affidavit service on in the meantime. Yes.
এটা দিয়ে দিন তো এটা দাদা
Yes, this is extension of interim order.
Lordship. Lordship.
Have you served?
Yes, yes.
Every service,
Also, I served a notice to after mentioning before your Lordship.
all served, all received.
Yes.
Every service filed in court today is taken on. Mr. Das in that matter.
The next
In
matter
this-
no can. First
Can one? ওটা কত ছিল? Already. Item number 14, who is appearing? Mr. Das, yes.
I am for the defendant petitioner.
Yes.
Here, my lord, what happens? My client, my lord, filed a previous suit. In that suit, my lord, for declaration and accounting, he lost. Thereafter, an appeal has been preferred before the Landry Kagdip court. Now, the opposite party, my lord, filed a separate suit. In that suit, my lord, an application for injunction has been filed. Landed court below allowed by the police help on the ad interim injunction. Did not get an opportunity of being heard. But an injunction order, but under of Supreme Court.
Without giving any opportunity. Why not? To file written objection.
Insofar as the
And order to itself.
Mr. Das, I have point upon him. Still arguing. Please take your seat.
I'm sorry.
Yes.
insofar as the grant of ex parte interim order is concerned, at that point, relevant point of time, the order of injunction was passed. They have entered appearance in the suit. Subsequently, they have taken steps of dispossessing me from the property in violation of the order of the injunction. I filed an application under 151 seeking protection that they do not throw me out, dispossess me, violating the orders. And that order has been granted by the court. Now,
But are they not entitled to file an objection to your application?
Objection to the 151A. No opportunity.
then I should
The learned advocate for the defendant submits that they want to file the written objection. Pays for time. Hard considered time prayer for written objection is rejected.
I cannot.
Ashun, by
Thing remains even except hearing.
This type of orders
Is
the court will
apparently
be
wrong.
very slow, very slow in implementing by police cell.
But when
I'm telling
objection
you.
goes, the hearing can be taken.
I'm
up.
telling you.
Your lordship delivered a judgment on this point. Your lordship get you the reference.
Why? Now the order has been passed. You search out.
Obliged.
I have not said whether it is in your favor or
No, I have not. I am not on that point also.
coming after 5 minutes.
Item number 15.
None appears for the petitioner at the time. Next.
Item number 16.
Preemption, my lord, entire share. Allow.
Entire share maintainable.
I don't think so.
Has to be.
Lord, I started Mr. Mukherjee, my lord, was appointed the amicus curiae. I agreed with it, obviously, whatever he says, but nobody can. There's one part I said that I think I need to talk to him. I didn't say that I don't agree with him. So I went back and I spoke to him.
What is Mr. Mukherjee's view?
His view, my lord, is a little weird. He says, my lord, that again, whatever is there, my lord, he says that yes, it can be done, but
it's maintainable.
Yes.
Language, Mr. Chatterjee says, when it says or, it's
if a portion or share of
it's not
that. No, not of. That was Justice Bhattacharjee.
That's what
he started hearing that as well.
Only thing is that would make a difference. If it says of,
that I say, moment you say share,
yes,
moment you say share, it doesn't say, my lord, entire share.
Does not necessarily
share can be entire. Mr. Mukherjee said differently.
Share is entire or part.
Lord, once exactly.
So if according to you, if entire, if that is said entire, Mr. Chatterjee, that will be a difficulty. Then, if a part is sold, preemption would not lie.
Exactly.
That is not the intention of the legislature.
I bow down. I bow down. Now what happened was, the hearing was almost over. But then, Milord, Justice
the larger bench.
Yes. The larger bench, Milord, thereafter didn't, Milord, convene itself. Because their lordships, Justice Homenshane and Justice Tandon was also there. Now the entire thing will have to be gone into again. But on the last day, my lord, just that part was to be clarified by Mr. Ghosh, who was assisting Mr. Mukherjee. Apart from that, the hearing was over. Yes, and I had to, my lord, submit the other part. But for some reason,
Mukherjee was appearing for one of the parties.
No, he was appointed amicus curiae.
Yes,
by Justice Tandon. So that part is still there, my lord, in the wings.
What part? Entire.
No, I bow down.
If it is entire, then it will be the other way around.
I bow down.
Portion will not be.
See, it qualifies it. If a portion or share of a plot of land.
Yes.
So either share can be entire.
Yes, entire or part even.
Problem is of a plot of land.
Yes.
Now, if it is share,
then it further qualifies with the expression offer at.
I bow down.
So it's the plot qualifies the offer at. It's a plot offer at.
Only come into play when the entire
Land Reforms Act now.
No.
Land Reforms Act. No, you can take use. So it qualifies that plot of land, qualifies that.
No, I
can't segregate plot of land. It's plot of land. Read it as a whole.
If I
the land of a land.
There in the full bench, my lord, it wasn't an adversarial argument at all.
Mr.
So I was, my lord,
It cannot be. Once
what your lordship is saying is what I was saying. But just that part is left.
Because cannot be an adversary.
Cannot be.
Cannot be an adversary because it only decides a point of law.
Nothing. If not, the matter has been
because after that it is to be referred to the bench concerned.
See, if a portion or share of a plot of land.
So you have to read it. If a portion of a plot of land,
No. If a portion or share of a plot of land of a land.
I'm saying exclude or share.
So, my lord, if the entire.
This is disjunctive. or makes its portion and share.
There are two situations, let's put it that way.
Yes, there are two situations. So you can read it in this way. If the portion of a plot of land,
I bow down.
or
My lord.
if
Well, I
a
completely-
share of plot of land.
Completely
So these are the disjunctive. So either of land portion or share of a plot of land. So both ways preemption lies.
I bow down, my lord. But I will try and show in this matter, my lord, things are a little different. Allow me to serve.
Only difficulty, Mr. Chatterjee, nobody knows when this issue will be.
Very difficult. Very difficult.
So unnecessarily, not only here, for the trial courts also,
bow
or
down.
the first appellate court, either way.
Lord, kindly, my lord, Justice Sen is now going to take up the mantle, my lord, in a few days. Lordship kindly talks to his lordship, my lord, and sees, my lord, that the full bench, my lord, is convened. I can also, my lord, when the matter is gone, it skipped
Because,
my mind, my lord. I
This
could have
is the
told his
only
lordship as
difficulty
well.
because no, that this was referred to by one of the coordinate bench.
Yes. Yes.
Why?
Because just honorable promotions, that was different. Yes, Chenarani, my lord, thereafter another division bench came, which was a little different. And then it went, my lord, to the larger bench.
Another division bench?
Yes. Then it went to the larger bench. Even Justice Shobhoshachi Bhattacharya, my lord, sitting in division bench also referred it. His own judgment in the single bench, my lord, he said was probably wrong.
Mr. Chatterjee, learned senior advocate appearing for the petition.
If your lordship remembers our old times, nowadays,
Yes, sir, not to put it in execution.
so that's a more classical way, but now the modern way is this.
So you want the classical way?
No, no, I'm very
The
modern.
restraint from restraint from putting the ওই judgment যেটা আছে সেইটা
Item number 17.
Lordship, item 17, Your Lordship, I am for the petitioner.
Yes.
So kindly allow me, Your Lordship, to appear online. Lordship, this is an order which is under challenge. Order 7 Rule 11 application, Your Lordship, has been dismissed. On that basis, Your Lordship, even Your Lordship, the KMDA and the government, Your Lordship, was a party. Section 80 notice was not given. Lordship, the learned trial court was of the view that the KMDA is a statutory authority, and Your Lordship, the state government, Your Lordship, there is no prayer, and that's why the notice, Your Lordship, was not actually required. That's the only reason.
Where is the plaint?
Plaint, if Your Lordship, kindly take page 20.
Page?
Page 20, 20.
20.
Lordship, defendant number 2, Your Lordship, is the Secretary, Kolkata Metropolitan Development Authority. And 3, Your Lordship, is the Special Land Acquisition Collector.
3 is, you have not claimed any relief against 3.
No, I have not, Your Lordship. Kindly see, Your Lordship.
Relief
Yes,
has
Your
been
Lordship.
claimed against the pro forma defendant.
Yes, Your Lordship. Now, Your Lordship, kindly take, Your Lordship, page 28, the first prayer.
If no relief is claimed, what is the necessity? And KMDA section 80 is not necessary.
Lordship, kindly see, Your Lordship, the middle portion, this particular prayer, Your Lordship, is couched in a fashion that there are two prayers. Prayer A at page 28, a decree for recovery of possession against number 1 from C scheduled property being part of A scheduled property on declaration that the plaintiff is the lawful lessee of A scheduled property.
Yes.
Yes. So therefore, there is also a prayer for declaration that the plaintiff is a lessee, Your Lordship, under the government.
Where is the case made out?
Your Lordship, kindly sees. One thing is very important. If Your Lordship, kindly take, Your Lordship, the written statement filed by Your Lordship, the KMDA.
Written statement for that purpose, order 7 rule level written statement cannot be looked into.
I'm not on that. I'm not on that.
Please
I'm
show
on the
plaint.
Yes,
Please show
Your Lordship.
the plaint.
Yes, Your Lordship. Page 22 onwards, Your Lordship, kindly sees. The
Yes.
registered deed has been paragraph 2. By registered deed of indenture, the government of West Bengal transferred, Your Lordship, a total area of 270 bighas equivalent to such and such in favor of Kolkata Metropolitan Development Authority, including the suit.
Yes.
So paragraph 2, Your Lordship, the main owner of the property, Your Lordship, is the state government.
Yes.
Lessee is, Your Lordship, the KMDA.
Yes.
And the plaintiff is the sub-lessee. So therefore, if Your Lordship kindly sees.
Relief against the government. What are you saying? No relief against the government.
No relief against the government, Your Lordship, but relief is against, Your Lordship, the KMDA, and
Yes.
KMDA, Your Lordship, is.
Only that section 80 notice is necessary upon KMDA.
Lordship, under KMDA, Your Lordship, is not KMC, Your Lordship, where the statute is separate. Here, Your Lordship, the West Bengal Town and Country Planning Act, Your Lordship, under that particular statute, Your Lordship, kindly sees once.
Yes.
The KMDA's formation scheme. Your Lordship, is section 16.
Section 80 is only against the government.
Is only against the government and public officers.
Government is not a party in the suit.
Lordship, section 16, if Your Lordship kindly sees, the entire body is regulated by the state government. That's why, Your Lordship, I was showing, Your Lordship,
No, that
section
is not.
16.
Maybe even if it is regulated, it is not government. What are you saying? Maybe an Article 12 authority, not a government.
But Your Lordship, the defendant number 3, Your Lordship, is still the state government, though Your Lordship, the relief has not been directly caused. But Your Lordship, prayer A, Your Lordship, is couched in such a.
Object is if a relief is claimed. What's the purpose and object of section 80?
But Your Lordship,
don't unnecessarily harass government. Prior to that, you serve a notice. If you get relief, you need not file a suit. That's the object of section 80, nothing more than that. So
Yes,
no
Your Lordship,
against the respondent number 3.
no, they have mentioned, Your Lordship, that they have not asked for any relief against the government, but ultimately, Your Lordship, is against the government.
No, no,
Lordship, prayer A, your lordship, is very clear. If your lordship kindly
That
sees
is
prayer
not
A.
against the government, that's against KMDA, not against the government.
But ultimately, your lordship, paragraph 2, your lordship, the government is the owner. That's why, your lordship, I have shown paragraph 2. The registered deed of conveyance, the government of West Bengal transferred it to KMDA. And thereafter, your lordship, the KMDA, your lordship, has been transferred in favor of your lordship, the plaintiff.
Thank you. This application under Article 227 of the Constitution of India is at the instance of the defendant number 1 and is directed against an order being number 45 dated 3rd of May 2025 passed by the Learned Civil Judge Junior Division 4th Court at Howrah in title suit number 1539 of 2018. First up, by the order impugned the application under Order 7 Rule 11 of the Code of Civil Procedure filed by the defendant number 1 stood rejected. First up, the learned advocate appearing for the petitioner submits that the special land acquisition submits that the suit has been filed without serving any notice under section 80 of the Civil Procedure Code, and in view thereof, the plaintiff should be, and a plaintiff is liable to be rejected. First up, the after going through the plaintiff, this court finds that the plaintiff slash opposite party number 1 herein, plaintiff is the opposite party number 1.
Plaintiff, your lordship, is the opposite party number 1.
The opposite party number 1 filed a suit for a decree for recovery of possession against the defendant number 1 from C schedule property, which is a part of A schedule property, upon a declaration that the opposite party number 1 is a lawful lessee of the A schedule property as per the registered lease deed dated 20th of November 2017, and for permanent injunction restraining the defendant number 1 from encroaching any further portion of the A schedule property beyond the property described in Schedule B thereto, and from changing the nature and character of the suit property. First up, after reading the averments made in the plaint, this court finds that the opposite party number 1 has claimed relief against the defendant number 1 slash petitioner herein in the form of recovery of possession and for permanent injunction. First up, the learned trial judge was right in holding that though the plaintiff claims to be a lessee in respect of A schedule property upon execution of the deed of lease by the defendant number 2, namely KMDA, no notice under section 80 of the Civil Procedure Code is required to be served upon KMDA, as the KMDA cannot be said to be a government within the meaning of section 80 of the Code of Civil Procedure. First up, the learned trial judge assigned cogent reasons for rejecting the learned trial judge after taking note of the decisions of the Honorable Supreme Court and applied the provisions of section 80 of the Code of Civil Procedure correctly to the facts of the case, and was right in holding that the said provision cannot be attracted to the case on hand. First up, for such reason, this court is not inclined to interfere with the order impugned. Accordingly, CO number such and such stands dismissed. There shall be, however, no order as to causes. Yes, next.
Number 18.
My lord, in item number 18, my lord, I beg to appear on behalf of the plaintiff decree holder petitioner, my lord.
Yes.
My lord, I filed a suit. It was decreed in my favor, my lord.
What is the order impugned?
My lord, the order impugn is that the miss case, my lord, it's an application for
If you're
expedient.
hearing of the miscellaneous case,
My lord, it's a police case application filed by the petitioner, my lord. The opposite party is continuously taking adjournments at, my lord, it is a decree of 2018. The execution miss cases of 2019, my lord, presently, my lord, kindly comes to page number, after page number 24, my lord. My lord will see what happened on the last date, my lord. They are continuously praying for adjournments and delaying my hearing of the police case application, my lord. The evidence of the petitioners have been
this
completed.
application under Article 227 of the Constitution of India is at the instance of the decree holder.
Leave to file it by 115, they can serve and then come back.
Leave granted to.
Milord, against an ex parte ad interim order of injunction passed by the learned appellate court below, while Milord that was refused by the learned trial court. Suit for declaration that Milord the plaintiff is a tenant on the basis of a leave and license agreement for 11 months. Rent is Milord 1,40,000 per month.
Who are you?
I am the defendant, Milord the property owner.
Yes.
Milord, sorry, Milord. Injunction was.
According to you, you are the licensor.
Yes, but the agreement is there, Milord, annexed.
Yes, so
Milord,
you are the licensor. So you have inducted the opposite party number, or you have allowed the opposite party number, opposite party to stay for a temporary period.
petitioner to stay. Petitioner in the revisional application. I'm sorry. Yes, sorry. Opposite party to stay. I'm so sorry. Opposite party. I'm sorry. Sorry. Opposite party to stay for 11 months. Milord, there is a provision in the agreement for extension twice for 11 months, but Milord, subject to mutual terms and Milord, subject to internal agreement.
Not agreed upon.
Not agreed upon.
So now the opposite party filed a suit
for declaration of tenancy right. Now, Milord, tenancy because of the agreement, firstly, Milord, he cannot claim. Secondly, Milord, 1,40,000.
Can you show me the agreement once, Mr.
Yes,
Bennett?
yes. Kindly, Milord, turn to page 57.
Page
57, Milord. I'm sorry, Milord, I'm having a soaring throat today.
Yes, Mr. Banerjee, this can be treated to be a tenancy agreement.
I'll show you, Your Lordship, the clauses. Kindly turn to Milord, clause 1. I'm not going by the caption. I'm not going by the caption.
What caption? Licensee, rent, license.
I'm not going by that.
Without that.
Kindly take clause 1. Milord, there has to be an interest created in the instrument in favor of Milord, the person who is Milord taking it on rent. interest in the property. Kindly see me the language. There are 7-8 clauses only. Kindly
That
take
is
the
Achinto Kumar Shah versus Nani Printers.
I am aware of that decision. Very well, very well. Kindly have a look at the impugned order. Kindly see the impugned order. My lord has never come across such an order, ever. That my lord,
Show me the trial court's order.
My lord, trial court's order, my lord, will get my lord at the end of the my lord brief.
At the end of the brief.
My lord, there should be my lord 2 certified copies, I'm sure.
No. Nowadays, certified copies are not filed.
Then my lord, 75, my lord, there is a copy. 75.
Are you being favored with a copy of the
No.
certified copy?
No.
Nowadays, that practice has stopped.
Just me দুটো দিতে হয় তো লোয়ার কোর্টেরও দিতে হয় হ্যাঁ
Yes. Which page?
Page 75.
Page 75.
Yes, my lord. Kindly turn to
judgment.
Kindly turn to 76, my lord, the last 2 paragraphs before the ordering portion. Thus, my lord, the returning, finding returned.
Yes.
It appears from the case record as well as the file documents and from the submissions of the plaintiff that although the agreement appears to be as live-in license agreement, its true nature is tenancy agreement. The plaintiff is a tenant.
Trial court also prima facie of the viewed tenancy agreement.
Yes. Not on that today, my lord, otherwise.
Next.
The plaintiff is a tenant under the defendants. Tenant has paid license fee in respect of the suit property security deposit. However, it also appears that the plaintiff has submitted that he is entitled to a restraint upon the defendants from destroying any essential to cause disposition of the plaintiff. Accordingly, I do not find any.
What is the meaning of this sentence, Mr. Banerjee?
Let us not go by, my lord, the English language.
Yes, next.
Accordingly, I do not find any.
First part of the observation is prima facie case made out. Why there was refusal?
Something more shocking is awaiting, my lord.
So if this is the finding, an interim order of injunction ought to have been passed.
Then take
and the appellate court passed an order of injunction. Rightly, Mr. Banerjee.
Kindly see the righteousness. Kindly see the righteousness.
Trial court's order was maybe in your favor, but from the observations, the ultimate conclusions are not.
I can vouch, my lord will be amused, my lord, to see, my lord, the impugned order. Can you have a look at this? Yes.
Please show me.
This is very important. Kindly take, my lord, the 6th paragraph of the first page from the bottom.
Of the appellate court's order.
Yes, the order
From
which
the
is
bottom 6th paragraph.
Yes. The 5th paragraph, my lord, I'm sorry. 5th. On being asked, the learned counsel for
On being asked, yes.
My lord, may I place it?
Yes.
On being asked, the learned counsel for the appellant submitted that the said agreement was not extended after 15 September 2024.
Appellant is you. No.
They.
Yes.
By placing before me the bank statements, it was submitted that the appellant has paid the license fee till July 2025. He is moving this minute in August. July was paid minute for the month of June. I have perused the said bank statements. It appears that a transaction was made between the appellant and the respondents, but it is not clear whether it was the license fee and whether the respondents have ratified the said payments as per receipt of license fees of the license, which already lost its force on 15 September 2024. From the letter dated such and such, it appears that the present appellants were requested to vacate in relation to the meeting held between the parties. The learned advocate for the appellant relied upon the said letter and submitted that by the said letter, respondent number 2 accepted them as licensee of the said premises. I have carefully gone through the said letter. Nowhere in the said letter it was mentioned that the respondent number 2 had received any license fee after expiry of the license. It appears from the said.
So, Mr. Banerjee, admittedly, you have given a letter dated 1st of July 2025.
Eviction notice.
Eviction notice. So you are admitting him to be in possession.
How can I deny that? I'm not denying that.
Yes.
And my client knows that he cannot be evicted without due process of law because his entry was not illegal.
So Mr. Banerjee, injunction has to be to protect his possession.
There, I join issue. There, I join issue. May I wonder aloud. I put this question to myself, of course. Can a person who is otherwise in present time not in lawful possession of the property is entitled to a blessing from the court for protection of possession?
How can you say that he is not in lawful possession? The dispute is
because of the argument advanced. Because of the argument advanced and recorded.
Mr. Banerjee, there are 3 admitted documents. One is the license agreement.
Correct.
2 is the notice.
Correct.
So the
entry lawful, he is in possession.
Entry lawful, he is in possession. And whether it's a
Without extension, admitted, licensee status as licensing admitted.
Mr. Banerjee, the prime question is interpretation of that document, whether it's a license agreement.
Let
or a
us, my
tenancy.
lord, interpret this against me.
So
For the time being,
yes,
let us, my lord,
if he is
assume.
in possession, so ad interim
My lord, let us
rightly and trial court's finding was.
May I take, my lord, 2 minutes more of your lordship's time?
Yes.
My lord, let me assume for the sake of argument and for the time being that, my lord, this is a tenancy document. My lord, having regard to the quantum of the rent payable per month, my lord, this is a tenant under, then, my lord, a tenancy under the TP Act. If this is a tenancy under the TP Act, eviction notice, service of eviction notice is, my lord, accepted, admitted. My lord, he is no more entitled to protection of possession from court. That, my lord, cannot happen. My lord,
So,
starting from Sayanaj.
So I'm recording your submission that you are accepting his as a tenant, and this is the notice under section 106.
My lord, I'm assuming the worst possible case for me.
Mr. Show me your notice. Did you treat him to be a tenant? Was it a notice under section 106?
It was
Show
not.
me.
It was not.
Then
notice a page upon. I'm assuming, my lord, for the sake of argument, that is his highest possible case. Even then, he is not entitled to protection of possession. My lord, court basically ushered
you can evict him without a due process.
I can't. I just can't.
Till now, you have not filed any evictions.
No.
Yes.
No.
This
But
application-
71 minute is the notice, risk part of the order. Just for entertainment purpose even.
Yes, yes.
Risk part. Therefore, it says the said letter can in no way be termed as a notice. Kindly see, my lord, the observation. The said letter cannot be termed as a notice.
Which paragraph you are placing?
My lord, this is third paragraph of the second page after conclusion of the continuing paragraph. It's one liner. The said letter can in no way, my lord, I do not know what's the difference between a letter and a notice. But my lord, that's, my lord, the wisdom of the learned judge. Then, the backbone of the stay of the present appellant in the said suit premises was the live and license agreement which had lost its force on 15 September. Therefore, present appellant is nothing but the legal occupant of the said premises. Then it says that, my lord, he is entitled to interim protection.
Mr. Banerjee, both ways. The trial court.
Kindly do not support this matter at least.
Mr. Banerjee, trial court's observation is, or the ultimate conclusion is not in tune with the foundational observations. Appeal courts also that.
A trial court holds, my lord, observe against me, passes an order in my favor. Appeal court holds, my lord, against me and passes an order, my lord, holds, my lord, in my favor, passes an order against me.
It has been well balanced.
Now, my lord will kindly balance all of this.
Now I will balance. Now I will balance.
Lord, may I, my lord, make this suggestion? My lord, I have, my lord, spoken to my learned advocate on record and my learned junior. Let us go back, my lord, to the learned trial court. My lord, kindly, my lord, issue directions for expedition of, my lord, the injunction
Mr. Banerjee, yes, can be done, but this is not your appeal. So that is what it's the difficulty.
Let me, my lord, serve notice and come back.
That is what
Kindly, my lord, allow me to serve notice
I
and
can
come
do one thing. You appear in the miscellaneous appeal. I will direct the miscellaneous appeal to be disposed of expeditiously.
Then, my lord, it will be two-tier proceeding. My lord, two-tier. My lord, first appeal court, then, my lord, trial court. Let us, my lord, go back to the trial court directly after service of notice. My lord, I am not asking for any, my lord,
After service, it will be a very difficult.
In the revisional application after
in the
service.
revision application, it will be very difficult for you to get it hard here.
Oh.
Ashun. So I'm supplying the reasons for the
This is against an order dated April 16, 2018. My lord, passed in miscellaneous appeal by the learned Chief Judge City Civil Court. My lord, it was against the order in misapplication under Order 9, Rule 13. My lord,
Order 9, Rule 13 dismissed.
dismissed, my lord, on the
Order
ground of
9, Rule
delay
13 simpliciter or with Section 5?
or with Section 5, my lord. Dismissed, and the subsequent misappeal was also with Section 5, my lord.
Also with Section 5?
Also with Section 5, my lord.
That has
Only
been
a period of
dismissed.
64, yes, my lord. Only a period of 64 days of delay was there in the
Yes.
misappeal, my lord. Lord, what happened was.
Where is the order impugned?
My lord, the certified copy of the order impugned is attached.
April 16, 2018. This is the reason, Mr. Banerjee, you have taken your seat. 64 days in preferring a miscellaneous appeal and 8 years, 7 years in preferring a civil division application. Is your maiden appearance?
My lord, before this court, my lord.
Before this court?
My lord, the delay, all I can explain is that, my lord, there was the ensuing COVID situation, pandemic all over the world, my lord. And then, my lord,
COVID?
My lord, then.
In 2018, the appeal court passed an order. My lord, where was the COVID
My lord,
then?
then subsequently, my lord, my husband fell ill. He's consistently under
What is the
supervision, my
suit
lord.
for? What was the suit for?
My lord, the suit for was ejectment.
Section 6 of the West Bengal Premises Tenancy Act.
My lord.
What is the decree has not yet been executed?
My lord, decree has not been executed. The execution is pending, my lord.
Ashun, this application under Article 220
application, my lord, for expeditious disposal of an appeal. But my ex parte ad interim order of
What appeal? What is the nature of the appeal?
ex parte ad interim order of injunction refused. I go up in appeal, my lord, appeal filed in February 2024. My lord, the same appeal, my lord, from that refusal of ex parte is still pending. My lord, before the district judge originally.
What appeal?
My appeal.
While proceeding with the miscellaneous appeal, anything left in the miscellaneous appeal against order to refusing to pass an ad interim
There is, my
order
lord.
is lost.
Well, observations made in the original ex parte also, my lord. Refusal.
So
order.
you contest the what observations? That's ad interim.
Ad interim observation.
Contest the temporary injunction. What's there in the miscellaneous
But they
appeal?
haven't entered appearance in the suit.
Why have you not entered
No,
appearance?
my suit. I'm saying they haven't entered appearance yet, my lord. They'll come and delay it further. My lord, my appeal is, my lord, coming up every day. The respondents, my lord, come up and they
The
ask
appeal
for
also
judgment.
they have not entered appearance.
No, appeal they've entered appearance. They come and ask for, my lord,
Sir, if you
time.
have made that prayer that I'm withdrawing that, direct them to direct the learned trial just to
So
dispose
every
of.
day, my lord, they come forward and ask for time to file the written opposition. Well, half the time, my lord,
You
the
will
learned.
not gain. I can direct expeditious hearing of the miscellaneous appeal. You will not gain because
Sure,
after
that's-
that, this way, that way, again another challenge on merits miscellaneous appeal. Your injunction application will be kept pending.
No, my lord, even if, my lord, I get something, I'll go back before. I will not press for, my lord, a contested hearing. I will go back before the trial court even if there's a remand. I will not come up anymore. Well, I'll try to save time, advise my client accordingly. But lordship, of the time being, my lord, will direct expeditious disposal of the appeal. No, they haven't filed their WO till date. But I also understand that on, my lord, most of these occasions, the learned court was also not sitting. Well, that's also recorded, my lord, your certified copies before your lordship. But we went before
You are the plaintiff.
I'm the plaintiff.
So you are not paying the lawyer's fees.
No, that is considered and disposed of. In the appeal, the learned advocate.
Maybe considered and disposed of. You are not paying the lawyer's fees.
Well, that was a misunderstanding completely. He had been paid the entire amount.
But the lawyer had to file an application before the learned
Extremely
court.
unfortunate. Extremely unfortunate. Well, these are things, as an advocate, I will never come and make these submissions before court. I was not there. I don't know what the actual controversy was. What I know is on paper, their application is refused.
The learned this
Given a time frame, my lord.
You said you will withdraw that, saying that.
No, not withdraw the appeal. I said I'll get it remanded back, my lord, if they come.
Make that prayer.
Lordship will give some timeline, my lord. As large as possible. I will not stand in those.
Not in these matters. Yes,
I'm
next.
grateful.
22.
My lord, I am appearing for the petitioner. My lord, due to some personal difficulties of my senior, I am paying for not this week.
On the
Number 23.
My lord, this is the second round of litigation. Initially, my lord, your lordship had directed, we had filed an application under Order 711 on the ground, my lord, that it is insufficiently, the court fees paid is insufficient. My lord converted, my lord, that application into section 11 and sent it back on remand for, my lord, further consideration. My lord, that section 11 is disposed of on the ground that, my lord, the whatever the court fees paid, my lord, is correct because they have not paid for anything, any recovery, but they've only paid for declaration. My lord, in my respect to submission, my lord, it's probably perverse because if your lordship looks at, my lord, the Court Fees Act,
Court Fees Act din to.
have a look at 7(4)(e).
7(4)(e)
for accounts, because this is a suit for accounts, according to the amount of which the relief sought is valued in the plaint or memorandum of appeal subject to the.
This is a suit for accounts.
Yes. My lord, have a look at the plaint and satisfies my lord self at page 33. It might have been couched in whatever way, but it's basically, my lord, I presume they are asking for accounts. If they are not, let them say that before your lordship, my lord, I'm fine with it.
Where is the plaint?
Yes, lord. It starts from 15, but the prayers are at 33. Or my lord, can you got it, lord?
Directing accounts be disclosed.
Yes. In respect of the said defect number 1 for the period commencing from such and such till the date of filing of the present suit.
The partnership firm.
HUF. A degree for declaration that the said defect number 1 has neither been dissolved nor there has been any dissolution in any manner whatsoever. So, my lord, the dispute is whether the HUF still stands or, my lord, it has been dissolved. And in terms of that, he wants, my lord, accounts. If he wants accounts, then 7F, my lord, has to be taken into consideration, which the learned judge has.
7(4)(e).
7(4)(e). I'm sorry.
It has himself value.
And just before I take your lordship to the impugned order, have a look at page 38. That's his schedule.
Page
38. Can you see he has valued it? Investment in such and such of equity shares of such and such, a company having its registered office such and such, having market value in excess of 3.
No, what is the relief claimed in regard to this schedule?
This is the schedule, brother.
No, declaration.
Yes, brother. Of
that,
accounts.
That declaration, that this is
Directing
the
accounts.
assets of the HUF.
Yes, absolutely.
HUF.
Absolutely. Directing accounts be disclosed in respect of the said defendant number 1. He has just put in that word declaration and says that it's 100 rupees valuation is fine. That's not correct. And the relief again, Miller, which he's claimed.
Yes, Mr. Dazutu, what do you say with regard to it? Not a suit for accounts.
I have not sought any my title or right with regard to those shares. Kindly comes to Millard.
No, did you pay for accounts?
My relief will speak for itself. Kindly
No, I'm asking you. You have couched your relief. Is it a suit for accounts, yes or no?
I have written suit for accounts, injunction and declaration.
So you want accounts?
Yes, pair A.
So yes. So if it is a suit for accounts, how is it to be valued?
As kindly see E.
Yes.
In all such suits, the plaintiff shall state the amount at which he values the relief sought.
Yeah,
which I contemplate that I will get at the end of the decree. Kindly see 7 Roman 4 E thereafter, according to the amount
at which the relief sought is valued in the plaintiff member of the appeal, subject to the provision section 11.
Exactly.
In all such suits, the plaintiff shall state the amount that at which he values the relief sought. So, my lord, it's on me.
And he sets for 3 crores 35 lakhs.
No, I have not. That's the valuation, that's the market price. And my lord, the law is well settled that my lord, court should go by the relief sought. I have not sought for any declaration with regard to my title. Where is my lord, may I put the question, my lord, to myself? My lord, kindly see the reliefs. Kindly go by the reliefs. My lord, court cannot go beyond the reliefs. I have not sought, my lord, and my lord, in the impugned order, my lord, court has, my lord, had held that I have not sought for any prayer with regard to my right title and interest with regard to those shares.
তাহলে অ্যাকাউন্ট চাইবে কি করে? JQ এসে অ্যাকাউন্ট চাইবে?
No, Mr. Chatterjee, even if it is for accounts, how do you say that it has to be on the basis of the amounts of the investments and other?
Lord, it's subject to section 11.
Because Mr. Chatterjee, this 7(4) entirety of all the clauses of 7(4),
my lord,
if you find that it starts with in suits,
my lord,
thereafter those ABC is
Lord, your lordship will see
now
first see 7(3).
7(3), yes, 7(3) is suits for movable property other than money.
Yes.
So it's
No,
not
other
this,
which doesn't have, which has a market value. So even if your lordship goes by that, looks to that, in suits for movable property other than money, where the subject matter has a market value, according to such value at the date of presenting the claim, and he has valued it as 3 crores 35 lakhs.
I'm not sought for any order on that.
Then you say that you are not pressing this relief. I don't have a
will
problem.
have to give a schedule in the code below.
I don't have a problem. You have. That's
Mr.
amateur use.
So Dasgupta, there is a distinction. There are two things. Now,
Whether it's see my reliefs.
Yes, yes, from the reliefs.
Yes.
Whether it's a suit under section 7(3) or 7(4).
Then I have sought for account. 7 Roman 4 C.
7 Roman 4
C.
C is
injunction.
Yes, declaration and consequential and for accounts.
And for accounts. So I have valued the suit account to my millet prerogative. And millet, kindly see the reliefs. Kindly see the reliefs of the plaint. At what millet my landed senior was showing.
Mr. Dasgupta, there has to be an objective standard for valuation.
And that is why section 11 comes into
There
play.
has to be an objective standard of valuation. I think year 1984 Calcutta.
We have other judgments as well. Even Milord, that's why section 11.
Value.
I have
something of the investment.
Millet, what
Investment
My
valued
is
at
probably
some crores.
talking about just the Anil Shane's judgment.
Yes.
Kindly see.
That talks about that objective standard.
Absolutely.
Millet, kindly see the reliefs.
I think 84 Calcutta.
Yes.
Somewhere near that 83, 85.
Milo will kindly come to page 33. I think Milad is on at page 33.
So, Mr. Dasgupta, it used to be hard. So
it has been hard. Milad, what they are doing every time, Milad, first time they came, the court, Milad, kindly see Milad's first order. Let us come to Milad's first order. Milad, kindly see Milad's order at page 75. Initially, they filed on the self-sub point of order 7 rule 11. Milad had sent after Milad, all affidavits are complete. They came, Milad, after final hearing, they came before the lordship, the court held.
Final hearing of
order 7 rule 11. The Milad, the order 7 rule 11 was dismissed.
Yes.
On this self-sub cause of action. Now, Milad, kindly see, they came up before the lordship on at page 75. Milad, at page 75.
Yes, yes.
Milad, kindly see, by the impugned order, the application under order 7 rule stood rejected. The learned senior counsel for the petitioner submit that the suit was not properly valued. The learned charger lacks the pecuniary jurisdiction to decide the instant suit. He submits that the learned charger did not make an attempt to ascertain as to whether the valuation suit was properly made or not. Learned senior advocate appearing for the opposite party submits that the learned charger has already arrived at a conclusion there is no irregularity in valuation of the suit or payment of the court fees. After going through the impugned order, this court finds that the impugned order of the learned charger has recorded that when 7 Roman 4 gives the liberty to the plaintiff to value the reliefs as per choice, there is no reason to force the plaintiff. So my lord has come to a conclusion. Force the plaintiff to pay court fees on the market value of the entire assets.
It's not my conclusion. It's recording in the finds that in the impugned order.
Very well, very well. I'm sorry. Pay the court fees on the market value of the entire assets and properties of the defendant number 1 HUF. It is
now it comes to my mind. There I have said under Order 7, Rule 11, it cannot be said because valuation has to be decided. So I said that issue will be decided. That
then will again affidavits were exchanged.
Yes.
Affidavits were exchanged pursuant my lord's direction.
Yes.
And again, this is a final order on Section 11 because my lord had converted Order 7 Rule 11 application into Section 11. Now, my lord kindly come to the order impugned first. My lord kindly go by the order impugned first.
Yes. Please show me the finding that.
Yes. Now, my lord kindly see paragraph 6.
Yes.
Now coming to the impugned order, Miller.
Yes.
Now coming to the instant application of the defendant, it is seen that the defendants have challenged the valuation of the plaintiff. It has been stated by the defendants that the plaintiffs in paragraph 1 of the plaint have claimed that the assets of the defendant number 1 in the knowledge of the plaintiff are those mentioned in the schedule of the plaint.
May I shorten it?
না 1 মিনিট স্যার 1 মিনিট
10 নম্বর বসাটা
আমাকে আমার মতন করতে দাও 1 মিনিট
পুরোটা পড়বি কি পর
Yes.
I am remembering Anupam Rai.
Yes.
As per the schedule, the plaintiffs have claimed relief in the plaint in respect of the shares fully paid up in such and such market value recorded along with the investment in the 10 numbers of equity shares of such and such. According to the defendant, the relief claimed in the suit is more such and such. Now, kindly come to 7.1. 7.1. Advocate for the plaintiffs have argued that the suit is one for declaration and accounts, and therefore value of the suit shall be as per the valuation assessed by the plaintiff. It is submitted that in a suit for account, the same is valued as per the opinion of the plaintiff, who is the plaintiff's thing to be fit to get to obtain after the final disposal of the suit. It is well stated that in the present case, no relief has been claimed with regard to any title or interest in respect of any movable or immovable properties. The suit only covers the illegal action of the communication. So, the communication is only the subject matter of the respondent and has never prayed for any relief with regard to the title in respect of the properties. In a suit for account, the plaintiffs are bound to value the suit by giving a fair valuation of the reliefs which he hopes to obtain. In such circumstances, the plaintiffs have prayed for. Now, kindly comes to paragraph 9.
Yes.
Paragraph 9, the suit, the relief has been couched. Relief has been stated, 10. Therefore, on perusal of the said prayers as well as the averments made in the plaint, it can be seen that the suit is for declaration, accounts, and consequential relief of injunction. The plaintiffs, by filing the suit, do not assert any specific possessory right. Now, kindly see over the scheduled properties being the shares, nor do they seek any relief for recovery of those properties or shares. In case the suit is decreed in favor of the plaintiffs, the plaintiff shall not obtain any possession of the suit properties or the shares. The reliefs to be gathered to the plaintiff in the case the suit is decreed is the relief of accounts as well as the relief of declaration that the defendant number 1 HUF has not been dissolved, and an injunction restraining the defendants from dealing with the properties of the HUF. Therefore, in my view, reliefs claimed in the plaintiff in the suit do not bring the suit within the purview of 7 Roman 3. Now, let's see 10.1.
Yes.
7 Roman 3 of the court fees provides for valuation in a suit for movable property other than money when the subject matter of the suit.
Strategy, so the finding is starting from paragraph 10 onwards.
Yes,
considering those are the observations.
Absolutely. 10.1 he has recorded. He has recorded. Yes.
10.1 says why not 7.3?
Yes.
And 10.2 says why 7.4e.
And he has recorded. That means I will not get the benefit of the shares or any declaration through the shares. It's only for the purpose of valuation, it has to be given. And he has recorded that even at the end of the decree, I win. I'm not getting the shares. It's in the suit. So, it's only the accounts and only the consequential reliefs. Now, kindly see 10.1, 4th line, where he says that relief in the claim, it can be seen that the suit is not recovery for any assets or movable or money or properties. 4th line, 10.1.
Yes.
So, neither I am getting anything And Milan, I have also not prayed for anything with regard to the Milan, any declaration that the share should be sent back to me or I get the shares. It's only Milan, the account that I seek.
Yes.
It's only the account. Now, Milan,
with a lot of respect to my learned friend, my lord, he's saying that he's prayed for accounts, and the learned judge has found that this is a suit for accounts. Why is he, my lord, may I ask this question to myself, talking about recovery of money or property? No, it is a suit for accounts. It
So
has
according to you, it is to be valued as 74E
or 3. That the court needs to find out. The court says, my lord, court finds that this is a suit for accounts, so there needs to be an objective value. My lord sees 74E once. That is why in only this section, my lord, section 11 is referred to. Section 11 is referred to. And that is exactly why your lordship said, my lord, objective value. He needs to argue on that, not whether he gets anything. He's getting account.
Where it refers to section 11?
On 74E. According to the amount of which the relief sought is valued in the plane, subject to the provisions of section 11. Shaking, my lord, boite nahi.
Book. My color is yellow.
Well, we go back to Justice Joytosh Banerjee now. My lord remembers that incident. Shudhi Jetu দেখাচ্ছিল. So he needs to argue on that. What he gets accounts. He doesn't get what the money belongs to the HUF. No, but he gets accounts.
Mr. Chatterjee, there has been some amendment.
Amendment? Lord, your lordship, may I look into that? What is the Amari book?
No, this is the court's book. 2022. What is your edition?
This is an old one.
I have 2024 on.
2020.
It's there.
Section 11 is not there.
Not section 11.
1870 Act, not the West Bengal court fees.
Lord, your lordship is looking at the
1870 Act.
Yes.
No, West Bengal court, 1970 Act.
1970 Act.
My lord is looking at the 1870 Act.
West Bengal court fees factory.
ওটা আলাদা ওই বইটাতে আছে ওই
নেই
আমারটা দেবো
That is why I was wondering because the section 11 was there. Now
that is why Justice Banerjee was correct. Well, it says so.
Court fees আছে কিন্তু আমি
থাকতে তো different argument altogether.
It says relief sought. I am also saying relief sought. It should be my prerogative.
No. Mr. Chatterjee, subject to correction.
My lord.
It's not only accounts which is section 11. Section 11 is all for A to E.
Yes.
Because
maybe
it's not only for account.
Very well.
Not only for account.
Very.
Because after that,
I bowed down.
there is a dash according to the amount
I bowed down.
applies to all clauses.
It goes to accounts.
Also accounts as well. Also accounts as well.
Absolutely. না জজ সাহেব বলছেন এই যে ড্যাশটা রয়েছে but as long as this applies to Millard accounts, then Millard, I have a right, Millard, to bring it to the court's notice. Court has found this is a suit for accounts. He has said his argument, Millard, if your lordship sees, his argument, the learned lawyer, Millard, paragraph 9, upon, paragraph 7.1.
Now, Mr. Chatterjee, what is the effect of this clause? In all such suits, please see the ultimate conclusion of or the concluding portion of that 7.4. In all such suits.
Absolutely.
So it applies to A to E also.
A to E all. Which he values the relief sought.
Yes. So
schedule Millard, he has valued it.
Values the relief sought, not the schedule.
Not the schedule.
Relief is the relief what he wants.
Absolutely. Yes. He is paying for accounts. In that accounts, he is valued for what? 3 crores 35 lakhs.
এটা সরিয়ে রাখো
3 crores 35 lakhs.
Let me now check up from the blue book. Whether it's same or not.
The new book.
Yes, no amendment.
No. But there's another thing. Your Lordship was of the opinion, Miller, that it goes for every section. If your Lordship sees this, if your Lordship just takes up C to obtain an injunction according to the amount of which the relief sought is valued in the plaint.
Now, Mr. Chatterjee, question arises. Now you you file a suit for declaration of title and permanent injunction in respect of a schedule of property. Let us say of large of immovable property which is valued at
much more.
Yes, of crores of rupees.
Title can be sought for rupees 100. Can be done.
Yes. So
but
now,
now
if you equate with this,
cannot equate. He wants to equate.
Because yes, there also the scheduled property, the valuation.
The worth is not given. In the scheduled property, Miller, the worth is not given. Once you go to, it's not given and it's not required.
No. There are two things. There lies the distinction between 7.4 and 7.5.
I bow down, Miller.
So if you
completely bow down,
the scope of the suit is within 7.5, then it's the market value.
I bow down.
So that's the distinction.
That's completely different.
That's the distinction between
if you
7.4 and 7.5.
Subject to correction by my lord, 7.4E is with respect to what he gets is accounts, and 7.5.
How long will it take, Mr. Chatterjee?
About 15 minutes. Milord, your Lordship keeps it just after the vacation. I don't think, Milord, anything happens before that. If there is a date আছে? Date আছে?
I give you liberty to apply for.
Date is on 18th November. 18th November.
It keeps it just after the 21 November. It keeps it just after the vacation.
At the last.
Usually calls every day the new motion list. So no difficulty.
My lord,
Yes, call the next matter.
Number 24.
My lord, this is my
You are gifting to the court.
আমাদের লাইব্রেরিতে সবাই গিফট মিস্টার কর্মকার বুক ওই জন্য হ্যাঁ
So I don't have a problem at all.
Yes.
My lord, this is my petition. My lord will remember, my lord. My lord, there was an application where, my lord, I had filed a civil division where, my lord, the defense had been struck off under section.
Struck off?
Yes, my lord. Landlord tenant.
Now what is the?
Yes, my lord. No, my lord. Defense had been struck off.
Impugned order now.
My lord, now, my lord, while your lordship was hearing that matter, my lord, that appears in today's list as item number 39. My lord, I have also preferred an application today challenging the dismissal of my section 151 application. My lord will kindly look into the impugned order. My lord, there were two orders passed on the same day. First, my section 151 is rejected.
Section 151 for?
My lord, extension of time to deposit my rent. My lord, because, my lord, there had been a deal. My lord, I had non-deposited for 1 month, 2 months. When I tendered it to the advocate refused, saying, no, I will not take it because there has been a non-deposit for a particular month. So, my lord, thereafter, I again tender for the next 2 months, again refused. I approached the court under section 151. My lord will see the impugned order. The first, the learned court says that no, it is rejected, because there is some direction of the Honorable Supreme Court. My lord, without referring to which direction he is referring to, my lord, on the same day he says, well,
challenging the order dated 17th of August 2020.
yes, that is so.
And 17th of,
My lord, two orders passed on the same day. First, rejected. Second says, very well, it's allowed, but subject to accrual of rights, if any. My lord, of course, I must point out that the period was mentioned incorrectly, so I had to get it again modified. And your lordship will find, my lord, the 1997 Act has been in the mind of the learned judge while dealing with my application. Complete erroneous discretion, exercise
so
of discretion.
247 says this court has no jurisdiction to extend
Yes.
the period of limitation.
Referring to a direction of the Honorable Supreme Court, which my lord, I am not aware of. He's saying in view of the direction of the Honorable Supreme Court, this court has no jurisdiction to extend.
All the decisions of the Honorable Supreme Court, section 151.
Very well. My lord will kindly see. My lord, this is absolutely incorrect application of law. My lord, this is 1956 Act, not the 1997 Act.
This is 1956.
Yes, but my lord, the learned trial judge refers to section 7(1), obviously of the new Act. My lord, this is a suit of 1983.
My lord, may I indicate just one thing, my lord? As of now, as we stand before your lord.
No, so this is a suit of 1956 Act.
Yes,
And my
yes,
lord,
and
the
1983.
1956 Act, in the meantime, my lord, the litigants have passed away, substitutions have happened, the,
So,
my lord, the,
this provision is interpreting.
my lord, I would only indicate, my lord, your lord, the valid friend is coming after 3 years, where my lord, today, my lord, the hearing of the suit is complete, it's for judgment.
Yes, my lord, the difficulty is, my lord, we informed the judge, the learned trial judge, that my lord, my CO is
Lord, your
pending here.
lordship would
Your lordship has passed.
kindly allow me, my lord, to have a look at the
lord, may I just-
application be served upon me and your lordship.
I have not
kindly
difficulty
Don't
with that.
proceed with the suit.
My lord, he has finished proceeding. My lord, the
Proceeding
judgment is reserved.
Judgment is
My lord,
reserved,
we
my lord.
informed the learned judge.
Your
My lord,
lordship
the
would
learned
kindly
judge did not
appreciate.
allow any adjournment.
Then
My lord, your lordship would
Yes, my lord.
kindly, your lordship would
It happened
kindly consider.
yesterday.
My lord, this
heard.
Matter.
My lord, 39, my lord, is the where the defense is ultimately struck off. On
Defense
the
is
basis
struck
of
off.
this order. On the basis of the impugned order which your lordship has just seen.
Item number 39.
Yes, yes. My lord.
Item number 39. You are appearing in that matter.
No, my lord.
I have instructions to appear.
You have
Same
instructions
party.
to appear.
My lord, no caveat had been filed. My lord,
Caveat was filed, my lord,
1
but
minute,
my
sir.
learned friend is coming
You have
after
a
2
copy of
years.
this, that civil division application.
My lord, that I have, my lord, as well as the order which has been passed.
Please give the civil division application,
My lord,
madam.
this is absolutely marked.
Item number 39 করে দিন। Yes, call the next matter. আর আছে কিছু? Yes, now it's okay, Mr. Chakravarti.
Well, only one word was missing. My lord, he has khas. The word was missing. My lord, I have kindly sees.
You have said khas.
Yes, my lord, I have written khas by pen. By pen, I have written it down.
How can you write it
No,
after
my lord,
that?
in his copy, my lord, I have written it. My lord, kindly gives me that leave to reaffirm it that portion. Otherwise, everything is okay.
In the order, it may be reflected there.
That khas word went missing. So kindly to reaffirm that portion.
আসুন, pursuant to That is already in that order. If that is failure, then you will be at liberty. I think that observation was made.
Yes, yes, in earlier. Yeah, what on failure.
Which paragraph?
Paragraph.
Permitted to stay subject to these
Subject to
conditions.
No, it's an undertaking that honor before any event, my lord. If I fail, my lord, by that undertaking, he will approach this court, not go back to executing court. And I can assure me that there will not failure. He is also a landlord.
No, I've said I've passed an order till that. I've said in the event of default, this stay will be vacated. I've passed the order of stay, Mr. Chakraborty. Stay is for a limited period.
That's true.
So if they comply with that, stay will be till that period. Nothing more than that. Automatically it will revive. Mr. Chakraborty, Mr. Chakraborty, that will create complications. Please apply your mind.
Yes, yes, I have applied. My client.
So if you do that, I can record. But
Client is insisting, my lord, whatever.
Mr. Chakraborty, you have to advise your client. What is the position of law?
I have stated.
I can incorporate that.
Time and again I have stated. That
So
automatically there will be no stay. You will proceed to the.
if you say so, I can record that. But then, Kunta.
I take in this time.
File that, it will not.
No. It's just one page, one paragraph reaffirm. Just chot kore dao.
Monthly list item number 1352.
None appears for the petitioner at the time of call.
Number 132.
Lordship, I am appearing on behalf of the petitioner.
Yes.
Expeditious hearing of the suit number 2054 2001 under section 23 of the special manager, which is pending before the first.
Who are you?
I am the husband, opposite party. Lordship, wife filed the case, but she never came before the court. Till date, she never came.
File a miscellaneous case for alimony.
I also give alimony.
You are paying alimony.
Yes, Lordship.
The order was when the order was passed.
Alimony?
Yes.
Lordship, kindly.
What is the stage of the matrimonial suit? Issues have been framed.
No, Lordship, wife never come before the court. That's the main problem.
This application under Article 227 of the Constitution. Yes, you are for the petitioner. Yes.
We have served the copy or sent your lordship. This is the affidavit sent. But in a miscellaneous case arising out of an.
There is a caveat.
Yes, ma'am, yes.
No. No, not caveat. There was a direction to serve.
Problem by senior to us.
Yes. But
But
there
your
was a
lordship-
direction to serve.
Yes, that is not the affidavit of service.
But after mentioning, did you serve them a notice? How do they know, Mr. Mukherjee?
May I just check it up whether it is prior to that or not? চার সাত No, Miller, it is. Yes, sir. Yes, sir. দেখি দাও application notice কোথায় সেটা দাও কি মেনশনিং এর সময়
না মেনশনিং আগে আগে দিয়ে তারপরে
Lord, I do not know whether your lordships brief Lord the mentioning. My instruction is that prior to mentioning of the matter, Lord, the notice was given, Lord, to them, and that was handed over at the time of mention.
When did you
Lord, I do not
when
know.
did you serve a notice?
I do not know whether the mentioning slip is there or not. If it is not coupled with any notice, Lord, then your lordship direct me to serve. Otherwise, Lord, I cannot do it. আচ্ছা আমি দেখি
So what is the urgency, Mr. Mukherjee?
So, my lord, the urgency, I being the landlord, I could not able to in a proceeding initiated by a third party, wherein in respect of the occupation charge, special officer was appointed. That was the ground, my lord, on which your lordship admitted. My lord, I am suffering, my lord.
So I could not follow you.
My lord, kindly see the order impugned before your lordship.
Necessity for appointment of an advocate commissioner.
Yes.
Now, please look at the mentioning slip, the urgency. দেখান তো।
এটা urgency ground
না না এটা তো
এটা তো
নোটিশ
আলাদা,
দরকার
এটা
যেটা
notice।
বলছেন না আর্জেন্সিটা আপনি কি লিখেছেন
ছিল এর মধ্যে
আরে সেটা বলছে না স্লিপ কথা বলছে
Mr. Mukherjee, I am asking you, what should be done?
আপনি তো লিখেছেন অন্য কথা লেখা আছে
What should be done?
Lord, it is a matter, my lord, where
No, what should be
where
done?
Lord, this thing
This is an attempt to mislead the court to get a matter upgraded.
Lord,
Henceforth, I will not accept any mentioning slip. If this is the urgency noted in the mentioning slip.
your lordship, not lord.
So you being an officer of the court, you say what is to be done.
It should not have been done. I cannot say, my lord, this thing, she is suffering, senior citizen, that is otherwise. But the right thing should have been portrayed in the mentioning slip that this is the order.
Execution case is proceeding and other things when there is an order of stay.
No, it should not have.
What is going on?
I
cannot believe the mentioning slip, what has been written in the mentioning slip.
Certainly, Lord, this should not
What
have.
should be done? I'm asking you.
Lord, your lordship, direct the matter to retain its position. Lord, your lordship, I cannot, Lord.
Call the next matter.
Item number 955.
The service to taken on record.
Mr. Shuddha Sattva Banerjee is appearing in this matter on behalf of opposite party, Your Lordship. I'm praying for an adjournment, Your Lordship. Due to some personal difficulties, he's not able to come, Your Lordship. Kindly keeps it tomorrow, Your Lordship.
Yes. This is the matter, my lord. This is the last order, mayor's order.
Yes.
This is the surface actions, my lord. 30 days notice, and then again 30 days notice has required to be given. Now the DIRT held that after every sale there has to be 30 days notice, which I controversy.
According to the last submission was that a settlement has been arrived.
Fails, my lord. They did not pay it. That is why Mrs. Mitra was there.
It has failed.
Failed.
Yes, what
Your
is this matter?
Can I take instructions on this, Your Lordship?
What?
On the settlement, on the last occasion, there's an order on settlement, Your Lordship. Kindly let me take instructions on that, Your Lordship.
Only.
Keeps it tomorrow, Your Lordship. Mr. Banerjee will address it.
Then after the vacation.
Only one request. May I, if
After the vacation.
I'm not saying only one request. May I?
Yes.
My lord, permits is not. Banks are suffering at large, my lord. All pan Eastern India. Now it is up to my lord to.
You can move your matter. You are the petitioner. Move your matter. Yes, you can move your matter.
May I narrate the brief fact of the case? In surface actions, Rule 8.6 says there has to be 30 days notice prior to sale. So we have generally we used to give 30 days notice. Thereafter, after first sale, there has to be 15 days notice. Now the Honorable DIRT held in one of the matter, my lord, which says that no, before every sale you have to give 30 days notice. Here I join issue, my lord. Before every sale we did
That is the impugned order.
That is the only. Once I have given a 30 day notice, thereafter it did not require. That is a small point, my lord. Once I have given a notice, thereafter 15 days notice is sufficient to give. They did not require to any.
Show where is the impugned order?
Certified copy, my lord, volume 1. Last volume, my lord.
Last volume?
Yes. Certified copy of the impugned order, my lord.
Certified copy is the last volume or the first volume? Last volume, yes.
I am sorry, my lord.
Yes, last volume.
3rd May order, my lord.
3rd May 2024, yes.
Yes, sir. So what happens in rest all over India, except this eastern region in which Calcutta DIRT is located, all over India the same rules is followed what is given in the Act. That 30 days notice is sufficient to give, and there are
show me the provision.
8.6, madam, kindly see one. Rule 8.6 of surface rules.
এইটাই সামনে আছে।
It says that about 30 days notice. Got it?
Rule 8.6.
Yes, yes.
So according to you, first sale there has to be a 30 days notice.
That is called intimation to sale, so that you can redeem your property.
Yes.
So we have given that.
But if that sale fails,
then thereafter we did not to issue a Rule 8.6 notice. Straightforward. Can you see the next one? If sale fails, subsequent notice has to be given 15 days notice.
If the sale of such is being effected, where is that 15 days notice?
Thereafter, I am Andika, I do not have the act. So can I see Rule 9.1 once?
9.1. No, that is 30 days.
Then the Rule 9.1, can I see?
Yes, 9.1 is 30 days. Where do you find this 15 days?
It is there, my lord. It is there. I am not. একটা বই আছে সারফেসে বই আছে একটা আরেকটা অন্য In proviso, it is there, my lord. If first
If
sale,
the sale is being effected by either inviting or by public auction, the secured creditor shall cause a public notice to be passed. Yes, so after you serve a notice to the borrower, then you have to give public notice.
yes.
Yes, but if that sale fails,
And I see rule
then
9.
you have to again make a fresh attempt to
Publication.
sell.
Yes, yes.
Publish, then you don't have to give the notice to the borrower.
Yeah, no, not required. Well, kindly see rule 86 once. Rule 86 is gone. Now kindly see
86 once.
then 91. 91. Yeah. Proviso, kindly see.
91 proviso.
Yes. Provided further that.
Yes.
Provided further that if sale of immovable property by any of the methods specified by sub rule 5 or rule 8 fails, sale is required to be conducted again. The authorized official published notice not less than 15 days.
Shall serve,
yes,
affix,
yes,
and
yes.
publish notice of sale
15 days
of not less than 15 days.
Yes, yes. I fully agree with that. So 86 once. So we have given the right to redeem the property. So you redeem the property. Now once they did not redeem the property, even if sale fails, not fail, whatever. So they did not participated to redeem their property. Then the rule comes to rule 9(1). So in first time it is 30 days. Suppose the first sale, then it has to be 30 days notice. Now subsequent 15 days notice, 86 not required. That is my whole contestation.
Yes, so if the sale fails,
yes,
you cannot revert back to 86, so it used to be 9(1).
That is a small issue, yes.
Show me how that has been dealt with by the learned judge of the appellate.
Para 31, my lord. Para 31.
31.
I'm not reading, my lord.
So here it has been held that even in case of subsequent sale, that 86 has to be
but that is
followed.
But that is not the law. According to me, these borrowers, my lord, taken away 100 crore rupees and odd. Every time I give 86 notice, that is not the requirement of law. Requirement is you give 30 days notice before publication of sale notice. So after this 30 days plus 30 days expires, every time we give 15 days notice. That is in all over India except this DIT Kolkata regions, this happens. The banks are suffering a large time.
But here, the decision of the Honorable Supreme Court was considered in Matthew Varghese. Do you have that decision once?
Matthew Varghese, I don't have, my lord. The only thing is that Matthew Varghese says, madam, I subject to correction, madam. Matthew Varghese says every time there is a 8-6 notice. Every time is first sale, 8-6 notice has to be given. But borrower has to given a time of 30 days to redeem his property. That is the only thing.
It is because here it also 8-6 says it's the first time.
Yes.
Before section or rule 8
yes
deals how the sale is to be effected.
Yes.
What steps are to be taken prior to that
Yes,
sale.
yes. We are following that.
Is, yes.
Yes, yes.
8-6 says that you have to serve notice upon the borrower
Yes.
for 30 days.
Yes. We do that.
Being affected by either. So first you have to serve upon the borrower, then publish in the newspaper.
Suppose it is for the first time,
It's
then
for the
30
first
days,
time.
30 days plus 30 days.
9 ticks in
After expiry.
Yes.
Yes.
After
Expiry of 30
no
days.
sale in the first instance shall take place before the expiry of 30 days from the date on which the public notice of sale. So sale has to be after 30 days of the publication.
Totally, fully agree.
That's 9-1.
Absolutely.
And if the sale by any of the one methods of 8-5 fails,
Yes.
and sale is required to be conducted again, the authorized officer shall serve, affix, and publish notice of sale of not less than
15 days.
serve,
Yes.
affix, and publish.
Yes, yes.
Not less than 15 days to the borrower for any subsequent sale.
My lord, I am totally agree with this. Beyond the statute, what he has.
Here is a case of subsequent sale.
Yes. A small issue, my lord, the pan India is suffering. Except this eastern part, all over India, this act is being followed.
Lordship, may I suggest one thing, Your Lordship?
Yes.
Mr. Banerjee is appearing in this matter, Your Lordship. It's a point of law, Your Lordship. Kindly keeps it tomorrow. There was already a terms of settlement between the parties. I don't have
Terms of settlement
instructions.
failed. Have you paid?
Your Lordship, I don't have instructions, Your Lordship.
What instructions?
I don't have any instructions, Your Lordship. Kindly keeps it tomorrow.
Madam,
with
this
Mr.
matter
Banerjee.
was appearing in the list. Yesterday, it has been indicated from 3 p.m. it will be taken up.
I am aware,
So you
Your
could
Lordship.
ought to have taken instructions
Yes,
whether
Your Lordship.
settlement
Kindly,
failed or not.
Lordship, Mr.
Now, officers are here, my lord. My have a specific
So officers are there. If
Kindly-
settlement has been made, they will not
I will
rush to
not
the
come.
court.
Yes, yes.
My,
They will be happy.
Yes, yes, much
If you
happier
have
than
paid,
Yes, yes.
Your Lordship,
you have,
if
if
the
you have
settlement
paid, they will be happy. They will not rush to the court.
has failed, Your Lordship, let me come back, Your Lordship. Let me come back.
There is no scope to pass an interim order at this stage.
Madam, if kindly stay the operation of the order, I can.
What is the effect of stay the operation of the order?
If not,
Appeal has been dismissed.
no, no.
What is the effect of stay?
May I?
Appeal has been dismissed. What is the effect of stay?
Effect is that I have to suppose this is the second sale. I have to abide by this judgment.
So then it's the effect of stay would be amounting to allowing the appeal. Can it be done?
My lord,
Can it be done?
I'm not saying anything. My lord, my lord knows I'm not. I will be out of court if my lord is something against the law. It is against the statute even. My lord, she has seen that.
The issue which falls for consideration,
Item number 7110.
It's difficult now. Let me see what.
Much persuasion this has come.
Yes.
Get
955, your application. Yes.
item number 710.
No, she is my
955. 955.
950 হয়ে গেল তো? ও 958 হয়ে গেল। Yes, then 710. Yes.
Lordship is my evidence of service and the notice after I mentioned the matter for arbitration. Well, this is a matter where my application for substitution of plaintiff 2 has been dismissed along with the section 5. There was a delay in filing the
What was dismissed?
Substitution application along with section 5. Substitution of plaintiff 2, the suit for the declaration and permanent injunction.
That is the substitution application.
Lordship, at page 9. Page 9 is my substitution application and page 23 is my application for under section 5. They are the brother of plaintiff 1, plaintiff 2 are the brothers and the defendant are also in relation, in relatives.
Where is the section 5 application?
At page 23, Lordship.
Yes.
Plaintiff, there was a delay. There was definitely one delay, but because all the papers was used to be handled by the plaintiff 2.
But you have not taken appropriate steps, sir.
It was
once the application for substitution is not filed within the specified time limit, it abates. Where is the prayer for setting aside abatement?
Lordship, section 5 has been filed.
Section 5 is neither here nor there. Section 5 is neither here nor there, sir.
But I'm supposed to get that 90 days, but filed.
What's the law for limitation? What is the period of limitation?
Lordship, is
for filing a
one
substitution
opportunity
application?
May kindly be given to the one opportunity may kindly be given because it's a suit in between. Lordship. So because plaintiff 1 is there, but there is she is.
So that's not the fact.
But the whole share will go.
You have not applied correctly. That's the difficulty.
That
you have not prayed for setting aside the abatement.
That happened in the. I know, but Lordship, this is a praying before your Lordship with the last opportunity to improve the thing, but this is only humble prayer before your Lordship.
You file an appropriate application, I can give you that liberty.
Lordship.
Do that.
So that can be allowed. Lordship. Just
this application.
Item number 1162.
Yes,
I appear for the
Mr. বলবেন না ওটা আগে করুন not ও
plaintiff petition. Lordships, in terms of the last order, OTS has been accepted by the respondent bank, and we have also paid our first installment in terms of the OTS, Your Lordship. The Lordships.
Then it goes. Then can you dismiss it?
Your Lordships finally keeps it after 3 months. Your Lordships, if the
Instructions to that effect. With respect to section 14, it's an appealable order. Mr. Banerjee on the last occasion said, Milord, Your Lordship had vacated the interim order. Then Mr. Banerjee came and said that everything will be settled. Milord, I have no instructions of any settlement whatsoever.
Your Lordship, the payment
settlement, it will work there, Milord, in the bank. There's no
Lordship, the bank has agreed and also taken the first tranche, Your Lordship. They have already.
Where is the settlement? Show me the terms of settlement. Give a copy to Mr. Chatterjee.
1 minute, I'll just give you. Your Lordships, we see that 10% has already been paid. Your
Madam, why don't you communicate between yourselves in the
Lordships,
meantime?
has been communicated, Your Lordship. They have only requested us to provide a non-real account for deposit of the money.
Let them do it. I don't have a problem. Then no question of keeping the revision application pending.
Yes, so if the you have given effect to OTS settlement, now what have you challenged now?
Section 14.
Yes.
Your Lordships, may kindly keeps the matter pending till the last tranche is paid, Your Lordships.
Till
the last amount, the last installment amount is paid, Your Lordships.
Appealable order, Your Lordship has held that revision doesn't lie. If they are proceeding with the OTS, let them proceed. The bank will obviously not do anything, Milord, if they have entered into an agreement.
Have you taken possession, Mr. Chatterjee?
We could not, because there is an order of stay from Your Lordship.
Your Lordship.
Passed an order of stay.
Lord, and I paid for vacating.
Where is that?
My lords, it's the, or if Your Lordship takes up the vacating application, it was passed by Justice Raja Boshu Chaudhary and before that Justice Pattanayak. See page 55 of that application.
So I have not passed any order of stay.
Your Lordship's court. The bench has. So this needs to go. Thereafter, Milord, what happens before the
No, but only one thing, Mr. Chatterjee. If there is a settlement,
Let them
they
do
are
settlement.
paying. Can you take possession in the meantime?
That is a matter on merits under section 14. If they are
13 order has been passed, you.
no, stay has not been granted. Milord, initially section
No, section 14 order has been passed.
No. Initially section 14 was passed. Thereafter, Milord, they challenged it. It was dismissed for default for some reason or the other.
Section 14 was challenged before the tribunal. Tribunal that was dismissed.
Dismissed. Again a section 14 file.
Again a section 14.
Challenging a section 14, challenging the self-same section 14, a section 17 is also filed. There they paid for stay.
No, I could not follow. If once it has been challenged, that has been
point. It is hit by res judicata. That's my point. Then stay was not granted.
Yes,
by the
where is
tribunal.
Mr. Banerjee?
Your Lordship,
Can we have a look at
Where is Mr. Banerjee?
Your Lordship, kindly passes it over. I will
ask him to come.
Yes, Your Lordship.
Ask him to come.
This is the fourth occasion.
Ask him to come by 5 minutes, 4:15.
Okay, Your Lordship. Great for you.
Okay, bola na.
Great for Your Lordship. Thank you, sir.
I'll wait.
Yes, call the next matter.
Item number 171.
Defendant is the petitioner before Your Lordship.
Yes.
Appearing on behalf of the respondent, Lordship.
The plaintiff filed a suit for declaration of tenancy against me. I am the co-owner of the suit property, my lord. He did not make party his original landlord, my lord. And in the suit what is
the order impugned?
The order impugned, my lord. After getting the injunction, interim injunction, he filed an application under section 151 of the CPC, and he is claiming that I am forcefully padlocked the garage place and
So that is ad interim order of injunction.
yes, no. Thereafter, after passing the ad interim order, my lord, he filed an application under 151 CPC.
That is what I am saying. So he's trying to implement the ad interim order of injunction.
Yes, my lord.
By breaking open the padlock.
Yes, my lord. And thereafter, he praised for an advocate
Please give
commissioner.
me a minute. Where is the order of ad interim order of injunction?
No, it is not annexed, my lord.
But admittedly, my lord, the tenancy, my lord, there was a tenancy agreement in which, my lord, I had roof right.
Yes, yes, Mr. Das, I will come back to you. Where is the ad interim order of
No,
injunction?
lord, it is not annexed, my lord.
You have a copy of
No,
the
my
ad
lord, I do
interim?
not have the copy of the ad interim order.
Ad interim, that's the basis. And you are challenging that and you have not annexed that. Yes, what is the stage of the injunction application?
It is in interim stage, my lord. But thereafter, he paid for an advocate commissioner.
No. What is the stage of the injunction application? That was the ad interim order. What happened after that?
After that,
Did you file written objection?
Yes, I filed written objection, my lord. He preferred an application under 151 for breaking the padlock of the garage space and roof and the staircase of the roof. And on that basis, my lord, the learned court will pass that I have to break the padlock.
Where is the plaint?
Plaint is which?
My lord, the plaint, it starts from, my lord, page
20. Page 15, my lord.
Page 15. Resolution of origin.
The defendants are the co-owners, my lord. They are not the actual landlord.
Where is the application under 151?
Page 37, my lord. Page 38, paragraph 6 is the relevant portion.
Yes.
Yes, ma'am. In my written objection of the 151 CPC, my lord, I specifically denied that the ground floor garage is used by me. And in the commissioner's report,
No, to this 151 application, you have filed an objection.
yes, my lord.
Where
It
is
is in
that?
page 42, my lord.
42, yes.
Annexure E. In paragraph number 5, that the plaintiff has not able to submit any prima facie document showing that the free access to the roof and the garage on the ground floor was provided to him as an incident of his tenancy at the time of his induction in March 2005. And before the learned advocate commissioner, the plaintiff opposite party admitted that
What is your name? You are Aloknath.
yes, my lord.
What is your name?
My name is Shipra Ghosh, and
so you are the heirs of Ashok Kumar, Ashok Nath.
No, my lord, I am the heirs of Alok Nath Rai.
No, from the plaintiff it says they are the heirs of Ashok Kumar.
It is
Ashok-
wrongly stated, my lord. It is wrongly stated. In my written objection of Order 39 Rule 1 and 2, I categorically stated that.
Where is the tenancy agreement?
Lordship, I have.
But kindly seize the page wallet which I have flag marked with.
So Omyo Nath Rai.
But Omyo Rai is the co-owner along with Shilpi.
So you are a tenant of Omyo Nath Rai,
Lordship.
not Ashok Kumar, Ashok Nath Rai.
Ashok Nath Rai, Ashok and Omyo are two brothers. But
Maybe
the property is
you are inducted by Omyo Nath, Ashok Nath. So what is your suit?
But it is a suit for declaration and injunction.
So declaration of tenancy right without the landlord, is that suit maintainable?
Number kindly seize the order.
Yes. Sir, is the suit maintainable for declaration of tenancy right without
The learned trial court has dealt with that issue. Kindly seize the order impugned.
No,
I am not whether
they have dealt with. I am asking you. The tenancy agreement is before me. Plaint is also before me. May have dealt with. I am asking you. You from this document you are not disputing. So according to you, you are inducted by Omyo Nath. Show me that you have implemented Omyo Nath as a defendant in this suit.
But Omyo, I had nothing to do with Omyo. Because it is only Shilpi and her daughter who are disturbing my possession.
Sir, you have to, how can you claim tenancy right against him?
Number kindly seize
You have sought for your declaration of tenancy right.
Kindly seize the prayers in my plaint, what I have sought for.
Sir, your prayer for injunction boils down from your prayer for
But I have not prayed for any declaration of my tenancy. Kindly seize the prayer in the plaint.
Prayer A. Why are you saying you have not prayed for declaration of tenancy right? Prayer B flows from prayer A.
Lordship.
And this declaration without the landlord suit is not maintainable. I can reject the plaint here and now. Plaint is liable to be rejected here and now. How can you maintain this suit against other co-sharers? And this ad interim injunction, you are sought for implementation by police cell. Is it permissible? Ad interim order through police cell? Ad interim order passed on the basis of the averments made in the plaint only, that will be implemented by police cell. Yes, sir, I am staying this. Come prepared.
1162.
Yes.
Short of the matter, I have taken instructions from the bank. They are supposed to give money in 4 tranches.
The settlement happened.
Now, but the bank accepts that if they give if they do not default in payment of those 4 tranches, we will not take possession. Now, if they default,
the agreement.
That's the agreement, and we are agreeable to that. And if they give the money, we will not take any possession. If they don't give the money, give me the right to take possession on the next day.
Lordships, Mr. Banerjee is appearing on.
Yes, Mr. Banerjee.
After this, what Mr. Chatterjee has said, after this, I have nothing to say. This is what we are also praying for.
This disposes of the entire proceeding everywhere. Entire proceeding goes. I'm accepting it.
No, entire proceeding, Mr. Chatterjee, I can, the order of the DRT is under challenge.
DRT is under challenge.
DRT is challenging the order under section 14. So, if they,
Your Lordship, if they
pay, section 14 order goes. So, if they fail
to pay, it revamps.
One thing I can do, this is rejecting their section 17 against section 14.
Section 17, section 14, stay was prayed.
Section 17
This is not for from rejection of section 17. This is from rejection of interim order.
Yes.
Refused.
Section 7 interim order praying
Was
for
refused.
stay of the section 14 order.
Yes.
Yes, correct.
I'm disposing it off by saying that this shall remain kept in abeyance. This order passed under section 14 shall be kept till the date of the last.
No, one installment if he fails.
Yes, I'm saying that it will be kept in abeyance till such and such date. However, if they fail to pay any of
the tranches,
the order of
I will
revives, and we will be give me those terms. What are the dates?
What are they?
Chance dates are your.
প্রথম ডেটটা কবে? 27th August. That's 10%, right? The next one is 25th September.
25th September, 25th of October, and 13th of November.
I'm told 27th of August is complied with.
27th August complied with. 27th of September is
25th is coming.
Is
Yet
coming.
to come.
of September.
Yes.
May I take my notes kindly?
Mr. Banerjee, where will go now? It's 4:40.
My learned arbitrator is standing in front of your lordship. I need to reach the venue.
Where he's going to come and ask for an adjournment.
Arbitrator is here. Unless he leaves, Mr. Banerjee, you have nothing to
do. He's somewhere else, Alipur or somewhere. So he will have to come all the way. Today, nobody stays in Calcutta High Court. Nobody. Every junior of mine, every day is out somewhere. Mr. Rice
One of your junior is always mobile.
And my friend is also.
One of your junior is always mobile.
My friend also.
I do not know whether he is here now.
He's not here now. I understand whom your lordship is hinting at. My friend said today that it's a miracle that he's been in High Court for 2 consecutive days.
This application, Mr. Chatterjee, you please remain.
I'm
Mr. Banerjee.
Lordship, may release him.
Yes, Mr. Banerjee.
Grateful, so grateful.
This application under Article 227 of the Constitution of India is at the instance of he's the borrower.
He's the borrower.
Why was it plaintiff? Here is you on the earlier occasions. That was not personal to you. It was. Yes. Yes.
That's always a blessing, my lord. If any time,
Times, Mr. Chatterjee, because after all, he was making submissions for his client, but at times it happens.
Wait for them.
Yes. Yes, call the next matter.
171.
হয়ে গেল তো
171 হয় 11
হয়ে গেছে
এটা 500 বার ছিল ঠিক নাম্বারে ঠিক
823.
There are two
Yes,
matters.
Mr. Chatterjee, what was your item number? দেখে নিন কোন
23 and 823 and 824 I am for the petitioner. My lord, there is
23, 824. Yes.
there is short point involved.
Very
The
short.
appeal stood abated.
Upgradation, we have not been getting.
This is the first time he is appearing, and this is the affidavit of service.
Sent because client
I have already served the learned advocate.
Should have served.
that is I also
That I do. But since
But
he is
Mr. Mukherjee, he says that you have not intimated him.
yes, kindly see, this is the first time it is appearing.
already appearing in monthly list. So client is staying in
Nobody
Calcutta.
here.
He have sent it.
No, nobody appeared. Don't take any technical point. There is
You are not ready.
No, my lord, I will have to do. But I have to, it will trouble your lordship not to. You have already.
No, there is kindly yes.
What is the
one
item?
point. The appeal was filed during COVID period, abated during COVID period. Setting aside abatement also filed during COVID period. In that application for setting aside abatement, in this case, we have filed an application for stay of the execution. That was rejected. Against that, we are before your lordship. Kindly see this.
What happened to that setting aside abatement miscellaneous?
That is still pending.
That is still pending. Then, Mr.
lord,
Mukherjee, I am directing that miscellaneous case.
One thing, my lord. This is not correct position of the what he is saying.
No. I kindly see the.
All right, let me submit. Well, what happened? We obtained a degree against the licensee who died. They are enjoying my entire property, even not complying.
This is the abatement of the title appeal.
Yes,
That is appeal.
yes.
We have filed the application for setting aside that abatement. The appeal
have no-
What is the decree for Mr. Rai?
For eviction,
License.
license.
Mr. Rai, all right, deposit occupation charges.
Well, 19 decimals with two house.
Let
Well,
the
a contract- they are
stay application be
Mr. Mukherjee, if you agree, I can set aside the abatement from here and I can direct the title
Yes.
appeal.
No.
disposed of.
Payment
Yes.
from 2000, my lord.
There are two things, Mr.
But-
Mukherjee, please allow me to make my
My lord.
observations.
My lord.
Title appeal stood abated, admittedly appeal filed within the, what he has said, during the COVID
Yes.
period. Death took place during the COVID period.
No,
Setting,
that is not.
That's
That
not
is the
correct.
negligence. That is the observation of the
No.
court. Kindly read
Kindly
the order.
see the order.
Kindly read the order.
My lord,
Court
the
said
appeal-
you did not even file any stay application after filing.
no, I've not yet come to the stay. I'm saying substitution application.
No, nothing. They did not.
Substitution not filed.
Section 5, again, and a different, my lord, two miscase has
No,
been filed.
miscase has been filed for setting aside
Yes,
abatement.
12. I
And,
have filed.
another is section 5.
Section 5 not filed.
Yes, filed. Page 80.
That is another.
That is, Mr. Mukherjee, that is what I am saying. There are two things. One is I can direct the miscellaneous case for setting aside abatement to be disposed of.
Subject to payment. He is occupying since degree 2019. And
So this is the refusal to pass an order of stay.
Yes.
Mr. Rai, you have to pay occupation charge.
Kindly direct the learned court below to decide what will be the occupation charge.
All right, I will direct
Yes.
what is the property I am assessing, deposit some amount, thereafter the trial appellate court will
he is enjoying
decide.
19 decimal of
What is the
land.
property? What is the property?
19 decimal of land with two-story
The
building.
plaint has been
New
amended.
building.
After degree, the plaint has been amended. Let them place the amended
No,
plaint.
Mr. Rai, what is the area of your occupation?
19 decimal. 19 decimal.
With
Two-storied house where?
In Holdia.
Holdia. What should be the occupation charges?
Then, my lord, that in Holdia, my lord, I have got no idea. Kindly direct us.
kindly direct us to deposit.
Industrial area.
No, no. Enter. Haldia is not industrial area.
No, no.
Haldia is not an industrial area.
Enter Haldia.
This is Calcutta port.
Malad,
That is not
kindly
industrial.
allow me to deposit some amount, 1 lakh, 2 lakhs as well, Lordship. Please,
He
let
has
this
enough
application be high.
Please deposit. What are you doing? It's exploiting that for commercial purpose.
Residential purpose.
When the decree was passed?
Degree was passed 2019.
2019. All right. So you deposit 3 lakhs.
As well.
Within how much time you will deposit?
Puja vacation is intervened within 2 months.
Some amount deposit before the puja.
As well, Lordship.
1 lakh, 1 lakh before 25th of September.
As well, Lordship. As well, Lordship.
Deposit or pay to him.
As well, Lordship directs, I can deposit in the court bill also. No problem.
Why
He can. What is the rate?
In the name of the client, you give a check.
I will give the check. I will give the check.
In
It will be dishonored, Mr. Rai.
No. Bank draft, then bank draft.
And with
no matter. Monthly will be decided by the executing court.
Monthly something also.
By the executing court, that will be decided.
Because
Your Lordship can
Mr.
dispose of the
Mukherjee, I do one thing. Because this is miscellaneous case is pending. Because there is no existence of the title appeal now. So since it has been abated, so as a condition, I'm directing him to deposit that. I'm also directing the miscellaneous cases otherwise ready for hearing. I'm directing the miscellaneous. What is the date fixed in the miscellaneous case?
In execution,
Not the execution, substitution, setting aside miscellaneous case.
7th November 2000.
Otherwise ready for hearing. Last week of not the execution.
7th of November. 7th of November.
7th of November.
Yes.
So I'm directing the miscellaneous case to be disposed of by the end of December.
As well, Lordship.
Yes.
By the end of December, till that time, the execution shall remain state subject to deposit of this 2 lakhs. Then if it is set aside, title appeal revives, you will be entitled to pay for occupational charges.
And if it is not monthly, if it is not
monthly,
all right.
This is the lump sum amount. After that, you have to pay for this application under Article. And what is the other matter?
Mostly affidavit of services are.
Affidavits of service taken on record. Yes, বাকি আছে দেখে দিন আর 2-1 Yes, yes, yes.
Item number 848.
May I please your lordship, in this matter, Willard, I am appearing for the petitioner defendant, Willard.
Number one plaintiff.
Yes, what is this matter?
Willard, assailing Willard 2 number of orders, Willard, where Willard our AWS for
AW, what is AWS?
Willard, additional detention, I tender apology, Willard. Additional detention statement, Willard, was rejected and Willard, the cross-examination of PW1 Willard was closed. Willard, assailing those 2 orders, Willard, I am before your lordship.
Cross-examination closed.
Of PW1 Millard. Millard, here in before Millard, I want to draw your lordship's attention to one aspect. Millard, they've amended the plain Millard on 4 occasions. Now, Millard, due to the Millard illness of
amendment of plaint was allowed. Thereafter, additional written statement you did not file.
Now, I couldn't file Millard because due to the illness of my advocate on record, Millard, who underwent bypass surgery, and Millard, he was ill for a considerable period of time.
What do you say?
28th of August 2023, Order 6, Rule 17 was allowed. Lord, on 6th or 7th days, Millard, adjournments have been paid in the court.
Millard, what I am submitting before the lordship is that Millard, the advocate on record was ill for a considerable period of time. Lordship, kindly takes up Millard my list of dates. Kindly takes up my list of dates.
What is the suit for?
It's a suit for declaration.
Sir, you have to pay some cost.
Millard, on the ground of illness.
Required.
Sir, you have to.
Millard, on the ground of illness, Millard. Millard,
he is suffering. Pay some cost, sir.
Millard, what I am beseeching before lordship is Millard, kindly consider one aspect. Millard, he was ill for a considerable period of time. He underwent bypass surgery. I will show you a lot.
Where is the document?
Show you a lordship. Lordship, kindly takes a page number 36. Lordship, kindly takes a page number 36 of my revisional application.
Documents are there. Advocate was ill.
Millard, one advocate was there. Millard, another advocate was also there. Millard,
Millard,
cost is required. Millard, 2G matter.
Maybe I am expediting this.
Advocate was. Then some within a preferable period of time. Within some preferable period of.
How soon can you file that?
Millard, on the next occasion?
Not on the next occasion.
Additional WS was filed.
On the next occasion from now, within how many days?
Not additional WS.
Millard, so far as my instructions are concerned, Millard, the next date is fixed before the London trial court is in Millard in the month of November.
Sir, November is long. How soon can you file? I'm asking you.
Well, we have already filed the AWS, Millard.
Filed.
We have filed. That has been rejected.
Also, I'm accepting that and cross-examination on the next date. PW1. Your witness.
My witness.
So, produce the PW1 on the next date. He will cross-examine.
Yes, yes.
This application under Article 220. Yes. চলো। এটা কোনটা হলো?
Today is no more. Today is no more.
My lord, only,
Today,
my lord,
your lordship will rise, my lord.
You don't want me to rise? You don't want me to rise?
Your lordship shall come back tomorrow.
Mr. Bhattacharya, I do not have, because they have
Yes,
to
yes, they are
transcribe
coming.
there.
Yes.
Now you will come and say, no, this order has not been signed,
Yes,
this order has
they're
not
very
been uploaded. They're also
They're
hard
also-
pressed because they have to,
only one
They have
thing.
to
they have to transcribe. So
subscribe it. And
I
they have
can
to,
continue, but it will be
and
putting
you'll also have
undue
to-
pressure upon this officer.
then you'll also have to stay here also. That is another problem.
My lord, only one thing, my lord, item 494, my lord, if your lordship, my lord, takes it up tomorrow, I'm not requesting your lordship to take it up today. My lord, the 494. My lord, the difficulty is that.
1, 2, 3, 3. I will have to proceed serially.
Yes.
You cannot take it up.
I have also objected.
My lord,
Yes, yes.
if it could be taken up tomorrow, my lord, the next date is on 18th. So.
Mr. Member, I have to proceed. Balance.
Yes,
Looks, so motions are there. So I have tried to accommodate.
Yes, yes.
It's 5:30 now.
I understand. I'm
No.
Please consider this.
Yeah, absolutely, your lord.
We are not giving pressure to your lordship, my lord. I know, my lord.
It is true, my lord. Take the matter hard tomorrow, my lord.
Yes, that's up.